Good morning, everybody. Happy Super Friday. Welcome to the Courtroom Files Live. It's nice to have you all here with me today. Since it's Super Friday, let's start early, about 15 minutes early, and we will begin with Jason Elmore. He, I believe, is going to do a sentencing, so let's see what's going on there.
Here in Missaukee County. We begin today's docket call by taking up the case of People of the State of Michigan versus Javier Cantu. This is file number 25-3621FH. Appearances, please.
Your Honor, David Denhound on behalf of the people.
Robert Hartel for Mr. Cantu, who joins me at the table.
Thank you very much. Court also recognizes before the court this morning Mr. Luke Blazak. He's an agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. We are here today for a sentencing on a case involving a conviction for possession of the controlled substance methamphetamine. The court is aware because it has received a written objection by the defense as to the scoring of offense variable 15. Before I get to that, give me just a moment to see if I had any other notes or corrections that I caught myself. I know the report that I have here was prepared recently and received in my office earlier this week. I'd just like to check, Mr. Blazak, there were a few unknown statements inside the criminal history on CFJ 284, pages 4 and 5. Did we have any updates just to add there? I just want to see if you received any further information. For instance, in entries 1, 2, 3, 4, 5, there was some unknown information. Did any of that come about?
It did not, Your Honor.
No problem. I just wanted to see if there was any further change that we needed to note there. Okay. Let's go ahead and I'll get to you just a moment, Mr. Hartel. Mr. Denham, any other changes, modifications, objections to the contents of the PSI?
No, Your Honor, and at the appropriate time, I'll just make an oral response to it.
Sure, no problem. All right, Mr. Hartel.
Just a few small ones, Your Honor. On CFJ 284, page 4, on the adult history on 1 of 10,
Okay.
where it mentions the sentence, it says 1 year prison. My client advises me he actually only had probation for that file, so the court is aware.
Okay. All right, well, we'll just, how about this? We'll say, well, I don't know, Mr. Denon, we could say probation. 1 year in prison doesn't sound right because typically prisons are more than a year. So we could say unknown. Yeah, thank you. I could tell you quite honestly, it's not all that applicable to my decision today, but I don't mind making sure that it's complete and accurate. The question is what proofs we have.
What one was it for you?
Number 1 of 10 on CFJ 284, page 4. It says underneath this position, 1 year prison. He's stating that it was 1 year probation. Clearly, I don't think it was a prison, but it may have been a jail.
The information I have, to the best of my understanding, is that it was a prison sentence, Your Honor.
All right, let's do this. Underneath the narrative, at least I'm going to propose this and I'll see if the council have any objection. Underneath narrative, after whatever those numbers mean, we can put down defendant, however, believes it was 1 year probation. Because it doesn't appear like we have a solid answer, and I'll make sure, and I'm letting the defense know that was from 25 years ago. So
I'm looking at a sheet that says commitment and sentence information.
well, let me look at this question here. Sorry, let me direct the defense to this question. Looking at 2 of 10. See how they're both the same offense and they have different dates of occurrence? But they have the same date for conviction. right? No, wait. The disposition for number 1 was given on the same date as disposition for number 2. So he would have been sentenced on 2 cases at the same time in the same court. So are both of those wrong? One of them wrong? Both of them right? Somebody's got to help me figure this out.
Those are both right, Your Honor.
All right, I'm.
My client's advising me that on 2 of 10, he did have a violation on that one that he did then go to prison for, but he believes that was standalone, separate from 1 of 10, Your Honor.
Well, it's got them both being sentenced on the same date. So, all right. Well, here we go. Well, I'll take back what I said, Mr. Blazak. We won't make any addition. I'll accept for what the defendant has to say today. It is better if we're able to have the best accurate information, but without that, something to point to it, we're kind of stuck. That's the challenge that a court always have, and the parties always have whenever it comes from a different state, especially, although you'd think geographically it wouldn't make that much of a difference, it tends to, especially if it's Arizona. Ooh, don't even get me talking about California. So I'll just leave it, but I'll accept what the counsel tell me and Mr. Cantu do. And by the way, it really doesn't have it's relative, again, it's a 25-year-old conviction. Both of them are. Okay. So, and they also are relatively, I don't have anything about necessarily a probation violation. So we'll leave it at that. Any other challenges besides the offense variable 15 argument?
Yes, just another small one, Your Honor. On CFJ 284, page 4, went to page 5 for the 4 of 10. It mentions that my client allegedly committed a new weapons offense while in prison. He advised me that he was involved in a fight, but no weapons were involved, just so the court's aware.
Well, I can tell you that 4 of 5 is followed by, or 4 of 10 is followed by 5 of 10. And 5 of 10 says, as a state prisoner, which would have been within the 5 years of the sentence date, there was a charge for misconduct involving weapons. So I've got another question where I've got 2 cases that seem to relate to one another, and one supports the other one. So I don't know.
With that, Your Honor, my clients advised me that on 5 of 10 that occurred while he was on parole and not incarcerated, but that's based on his recollection, just so the court.
All right. Well, either way, it still would be while on as a parolee. I'll accept that kind of as an argument that I'll apply to allocution. By the way, Mr. Hartel, I wish Mr. Champion were here so I could tell him this is why this court will not accept pleas to charges when the facts don't meet the charged offense. That's a different story. That's a case over in Wexford County, and this proves my point. Just tell him I said that if you think about it. All right, thank you. Oh wait, offense variable 15 now?
Offense variable 15 is the only other argument.
All right, go for it. Thank you.
I appreciate, Your Honor. It's the position of the defense that the information in the report does not support it being anything other than for personal use. When the police confronted my client, he told them it was for personal use. And in the PSI interview, he told everyone it's for personal use. We know it's a relatively large amount.
How much was it again?
I believe 6 ounces?
6 grams.
6 grams.
6 grams. Yeah, I was going to say it.
No, 6 grams.
There's a difference in grams and ounces.
Yeah, 6 ounces is a lot.
Yes, Your Honor.
And that's 6 ping pong ball sizes.
No.
That's quite a bit.
Yeah.
I got it. All right, so we've got 6 grams.
Correct.
I got it.
All right.
Thank you.
I'm using the right metric there. He advised me that although obviously it's still illegal to use that controlled substance, he was going on a relatively large road trip. As the court did note, Arizona is nowhere near Michigan geographically. He was hoping not to go through withdrawals. He took enough for personal use. His girlfriend wasn't aware. He was trying to conceal that from her. The remainder of it was the amount he was expecting to need to be able to return at the end of the trip. So it's our position that it was personal use only.
Okay.
We'd ask him to be scored at 0. Thank you.
Thank you. Mr. Denon.
Thank you. The probation department scored this offense variable based on the context and circumstances of the traffic stop. defendant was coming from Arizona. He was prohibited by the terms of probation from coming this far. He was in Michigan. The amount is also a factor, 6.88 grams. The fact that there was a 5-inch blade knife, and also where this was found. This was in a box, or a magnetic box. It was found in the trunk. So those were some of the factors that the probation department were looking at when they scored that here.
All right. Mr. Blazak, when we look at offense variable 15, there are two ways in which to score 15 points. First of all, we know that underneath those two, it talks about a Schedule 1 or 2 that is a narcotic. We know that this is not a narcotic, or a drug described under 2 other statutes. And it says, with the intent to deliver the mixture in this state. So I don't think it's the first one. I assume it must be, or is it under the second one? I don't know. So in other words, tell me which one of the 2 you used. The first or the second? Sounds like it's the first. The one at the top, which is the third one down, would have to say 50 or more. So we know it's not 50 or more grams. So now we're down to just a second of the 2. Right? So how does it, what was your logic? In other words, how does it show, quote, intent to deliver the mixture in this state?
Your Honor, I was just looking at the fact that he'd come from another state with the quantity that he had and still had that quantity. I guess if he had brought it over for personal use, he'd still maintain that amount.
So here's a couple key questions. Were there any other like individual baggies, you know, where typically one might expect that if somebody had a larger amount, and 6 grams, by the way, could be 25 different hits, that then they would say, all right, well, listen, I've got it in this little container. And we could say over here, he's got a bunch of jeweler baggies that clearly shows one might intend to put them in that baggie and distribute. Were there any other baggies, scales, anything else like that?
There was not.
Okay. All right. So that's my question, to show whether or not there is proof by a preponderance of the evidence to support that there was an intent to deliver in the state. Now, the locking up in the box, maybe somebody just doesn't want their meth stolen. I don't know. But there wasn't anything else, any other scales, anything else like that. All right. Am I missing anything else, Mr. Denham?
You are not, Your Honor.
All right. Thank you. Mr. Hartel, I could invite you to make further comment, but you don't need to.
No further comment, Your Honor.
Good choice. Keeps the record shorter. The court will grant the objection as to the scoring of offense variable 15 at 50 points. And we'll make that 0. That brings the total offense variable points down from 56 to 6, which I know is going to bring it down from an offense variable level 5, most likely down to a 1. Let me get to our D grids. So that is going to bring our D grid from 38 to 76 down to a 10 to 23. And again, that offense variable level went from 5 down to 1. Anything else, Mr. Hartel, as to the PSI?
That's the PSI.
Allocution, sir?
Yes, Your Honor. I would ask the court to factor in the sentencing 1 that we do, again, believe it was just for personal use. My client.
I already factored that in. It's
Oh,
already done. It's
thank
already
you.
scored that way, so I have to consider it as such.
Thank you, Your Honor.
Yep.
And in a moment, my client has prepared a personal statement. I considered emotional heart to heart with him yesterday, him telling me about his history of addictions, how he wants to overcome that. There's obviously many triggers in life that can cause that, including but not limited to, and I confirmed that he's okay with me mentioning this, but his son did die in 2016. And well, that was a few years ago. That's a trauma that still haunts him. He is still perhaps in the past trying to wean himself off his addictions. He's not one of the more extreme, I'm cautious to use the phrase faces of meth, but we do see more extreme examples. He doesn't want that to be that way. He does realize whatever happens here, he's going to have to go back to, I believe it's Arizona, right?
Yes, sir.
because he still has probation issues there. So even if the court were generous enough to give him the lowest possible end of the sentencing guidelines, it's not like he's going to just be released back into the wild. I don't doubt they'll most likely come and get him, if I understand how that works correctly, and he'll have to deal with his comeuppance over there as well. But he has been using his time productively while in the jail. He has been doing stuff with CHS, CMH. I know somebody came right up to me when I first came in the room and asked me to mention Bible studies, because I believe he's doing that with some other gentlemen at the jail. I do have proofs, but if the court's, I don't know if the court wants me to show them to the prosecutor and then to the court as far as participation in CMH and things of that nature.
Sure, go ahead and show them to Mr. Denham.
Sorry if we didn't see you earlier. It's a letter of support and just some proofs he's doing things. Let me approach him.
You may. Thank you.
I'll say a few other things as well.
You may keep talking. I'll go ahead.
I appreciate the multitasking, Your Honor. As was noted, he was going on a bit of a vacation with his girlfriend. He was, even at that point, even with somebody close to him as his girlfriend, ashamed of the point where he was trying to conceal it from her. He's not sure if he'll be able to respark that relationship or not. I know this gets broadcasted, so if she's listening, he does want to try to patch up all those relationships. I don't want to play too much into that because that's the type of counselor I am, but he has some things to add at the appropriate time as well. Thank you, Your Honor.
Thank you. I'll be back to you in just a moment. Mr. Cantu, you're the last person from the wall here. Mr. Denham.
Thank you, Your Honor. In response to the opposing counsel, mentioned a few things. I want to bring up a few concerns of the people. It's not believed that Arizona will pick up the defendant. So there is some concerns about that. We don't believe that ultimately that he would be picked up. Also, there was a used straw used for meth in the center console. So I guess there's some question what has in regard to the failure to disclose to significant other. The facts are somewhat concerning. This was back in June. The defendant was stopped in a traffic stop here in Michigan. He was coming from Arizona. He was prohibited from being here by the terms of the probation. There was a large 5-inch blade found in the vehicle. And as has been mentioned, it was a relatively significant amount, 6.88 grams. So fairly significant amount. So there are some concerns that I guess are demonstrated by the facts of this case. And with that, we will leave it to the court. Your Honor.
Thank you. One moment. All right, Mr. Cantu.
Yes, sir.
You have the right to make a statement. Is there anything you wish to say before I issue the sentence today?
Your Honor, Mr. Prosecutor, first and foremost, I would like to apologize to the state of Michigan, my family, and everyone I have affected negatively with my poor choice that I have made. I know that I have to face the consequences for my actions. I just ask for some empathy and mercy on my sentence so I can get back to my home state and to my family. By allowing drugs and negative influences into my life, I turned into someone I am not, and to have a past I'm not proud of. But Missaukee County has allowed me to be the real me, the man I need and want to be. I would like to give thanks to Ms. Nikki Platts, Catherine Michael from CHS, and Christina Van Houten from CMH. They have given me tools and knowledge on how to rebuild my life and to become who I want to be, a respectable, honest, and genuine man. These services and resources are awesome. I've never had access to anything like this before, so thank you. I am looking forward to the opportunity to put these changes to use where it matters most. I would also like to thank the GROFF Church and all the churches that take the time to come and share the word of God with us here in Missaukee County. Thanks to them, I now have God in my life, and I now walk with Christ, like many others do here now as well. In closing, I want to once again apologize for my actions. I know I have to face the consequence of my choice and addiction. I just ask for a fair and just sentence. And if it is deemed necessary to keep me here in Michigan, that I be able to attend a rehabilitation program to continue my sober Christian life as opposed to another prison sentence. Thank you, Honor, for your time and consideration.
Mr. Cantu, you mentioned having gathered or learned some tools from Ms. Platts and Chief of Mental Health and all that, tell me, what tools have you learned that you didn't know before?
First and foremost, my own self-worth.
Okay.
I've had a rough life, you know, streets and all that stuff. And I never knew what my self-worth was and that I'm worthy of having a good life. And it's okay to take the time and make maybe not the popular choice with my peers, but to do what's right in my heart and to do what's right for my family.
What other kind of tools has they taught you or helped you learn that will help you avoid being back in the same situation again? Because obviously you were on probation for a meth charge down in Arizona.
I know, instead of when life gets hard, instead of turning to drugs and doing like that, I could turn to scriptures. I can turn to a program. I need to look for these resources. I need to surround myself with better peers. I need to not be ashamed to speak about my feelings and how I feel and what I'm thinking. I know it's cliche and everything, but most men were not shown to. Where I'm from, you don't cry, you don't show emotion because that's weakness. And being here made me vulnerable and made me just take a good look at myself and accountability for myself and my actions.
All right. All right, thank you. Well, as we know, methamphetamine is the scourge of our communities, not just here, but even across the state of Michigan, further and across the country. In this situation, the defendant was on probation, was allowed to leave one state, came to our state, excuse me, and still has that warrant out there for him. But again, he was on probation for a prior meth charge. This defendant is 43 years of age. He should know better now. He's no longer a kid, which is what he would have been when his criminal history began. I will note somewhat positively here, he had a 6-year gap in time back from 11 to 2017. He had another 5-year or a couple year, 3-year gap. So it's not like it's happening every year, but still it does seem to happen every 5 years or so. He ends up back in trouble. And he has violated, looks like either he was committed an offense in prison or on parole. He's had a couple other prior probation violations. And again, in this particular case, he was on probation for a meth charge, which was a possession, and he had a prison sentence. So, first of all, I'll make some comments. I really appreciate the work that Ms. Platts and those do for us here in the county jail here in Misaki, and also what Catholic Human Services does for the people there in the Wexford County Jail. So I'm glad that you're able to participate in those groups, and I like to hear that what's being done is being absorbed. I just hope that it is. Very similarly with the people who come in and often say, hey, I have found Christ and so forth. Well, I hope you have, but I hope you don't do what a lot of people do, is that is when they get out of the jail, they just start running and they leave Christ waving in the background. So everybody finds religion in foxholes or in jails. The problem or challenges is whether or not when they leave, they remember that, as well as whatever they've learned regarding substance use disorder. Okay, we have a straddle cell here now instead of a presumptive prison sentence. The court must establish the reasonable proportionality of the sentence. I can do so here by looking at the fact that he was on probation for the same type of offense from another state, that he had violated probation at least in a couple different ways, and he's had other issues in the past with complying. And I'll note here that the defendant has had a substance use disorder problem with methamphetamine now for nearly 9 years. I'll also note that he has used marijuana and alcohol for quite a long time as well. In fact, If I do my math somewhat correctly, those have been problems since he was a young person. I hope that he decides here that on CFJ 145, page 1 at the bottom, you don't have to do it now, but I want you to think about putting end dates for marijuana and alcohol. Somebody who is dealing with one substance issue tends to use another substance to cover up whatever the same problem is. My father used to build highways, was a highway inspector. He taught me once as a kid a valuable lesson. When there's a crack in the highway, some people just go around and put a little rubber or tar over the top and they don't fix the crack. Well, you still have a crack in the road. So let's take out the crack, remove it out effectively, and you can't do that unless you're sober entirely. So I hope that as you're sitting in the jail, because I'm going to give you a jail sentence, I'm not going to give you a prison sentence. I hope you think about removing yourself, removing those substances also out of your life. Even if they tend to be legal, it doesn't mean they're good. It's kind of like gambling in Michigan. I see it all the time now on television. It's legal, yet it ruins lives. I don't know why we made it legal, but still, these things can and do ruin lives for some people, and I hope that you consider that. So the sentence of the court is, because the defendant's already on probation to another state, the court is not going to issue a probationary sentence. The court sentences the defendant to the required $68 state minimum fee, $130 crime victims' right fund fee, the $300 court cost, a $1,000 fine, a $300 attorney fee. There's a $60 DNA fee payable to the Missaukee County Sheriff Department. Again, there's no supervision fee, and the court sentences the defendant within the guidelines, and I'm going to sentence him to 330 days with, what was the credit again? 155 days of credit. Again, I find that sentence to be reasonable proportional based upon the factors that I've already discussed today on the record. That will give the defendant another couple months to work with Ms. Platts at Catholic Human Services and so forth. And I hope that you take care of what you've got to deal with. You're not forced to leave the state of Michigan. It's a great place. We have colors that they don't have in Arizona, blue and a lot of green. And we're getting ready to have a lot of white. But I understand if you do return to Arizona. All right. But again, you're also welcome here. Anything further that I've missed, Mr. Blazak?
No, thank you.
Mr. Denno?
No.
Mr. Hartel is going to bring to Mr. Cantu two copies of one document. Yeah. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of the other document. This document tells you that you have the right to appeal the conviction and sentence that I've issued today. Because of the guilty plea, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of that document. Please make sure if you do dispose it while you're sitting in the jail, do not throw it into the toilet. It will clog the system and cost you a lot more money to fix. All right. Do you understand?
Yes, sir.
Any questions?
No.
Mr. Cantu, although I anticipate you're going to leave our great state when you go back to Arizona. Please, for your benefit and those who care about you, learn the lesson, figure out how to stay off of this garbage, because it's not going to help you. It's just going to ruin you, and it could kill you. And I, for one, even though I'll probably never see you again, although you're more than welcome to stop by and say, hey, Judge, things are great. I would hate it if I found out that you passed away. I really do care about people, and I want to see you get this stuff out of your system. Man, if I could talk myself out of a job and get rid of meth, I'd be happy to get back a third of my paycheck. But since it's probably not going to happen, human nature is my job security. I'm going to get that on a t-shirt one day. All right. Good luck, sir. Thank you. We're adjourned.
Happy Friday, everybody. Welcome again to the Courtroom Files Live. It's nice to have you here. So, having spent the majority of my life in either Michigan or Arizona, there are some truths to what Judge Elmore was speaking right there. They do have more blue, green, and white in Michigan. However, counterpoint, Judge, we have better sunsets here in better sunsets here in Arizona. We have less shovels, and we have better respect of our constitutional rights. So I think I'll stick with Arizona at least for now, personally. Let's head down to Florida. We'll say good morning to Wade Mercer, and hopefully he gets things a little more right than he did yesterday.
Case there is probable cause for the charge. Mr. Laster, your criminal history looks great. I don't think that you've ever been arrested or charged with a crime before. Is that accurate?
Yes, sir.
The problem is that according to the jail sheet, and there may not be a problem, it may just be maybe a good reason for this. The jail sheet says you're 30 and under unemployment, it says no. So my question is, I always like to know if someone's employed or not, because typically if people are employed and they have a job, they're less likely to get in trouble again. So Mr. Latcher, do you have a job?
No, sir.
Okay. And where do you live at?
Mariana, have his
Do you live with someone or you live by yourself?
with someone,
Who do you live with?
my girl.
So how do you provide for yourself if you don't have a job?
I get income every month.
You receive some type of disability income or some other income?
Disability.
Okay. And that's a valid reason for not having a job. So you have a disability income check you receive every month. Is that right?
Yes, sir.
Okay. Fair enough. And I may have said this, or I think I said this, that your mom's in the courtroom. Is that your understanding also, ma'am? Okay. All right. So Mr. Laster, let me see if the attorneys have any additional information, and then we'll address your bond or your release status. Ms. Harris, anything on behalf of the state?
Nothing further, Your Honor.
Mr. McDaniel?
Nothing, Your Honor.
Mr. Laster, given that you do have income, that's the main thing I'm concerned about, and make sure that you're not just laying around not doing nothing all day. That's more likely to lead you to getting in more trouble. So I'm going to let you pick between a bond and a conditional release. It's entirely up to you. If you want to post the bond I would set for these charges would be $2,500 on the misdemeanor and $5,000 on the felony. Your total bond is $7,500 cash or surety. But I am going to offer you a conditional release based on what you told me today. Either way, you would have a condition of random urinalysis. Has he been explained what a conditional release is, Mr. McDaniel?
Yes, Your Honor.
Do you have any questions about the choice between the bond and the conditional release, Mr. Laster?
No, sir.
Would you rather post the bond or accept the conditional release?
Conditional release.
Okay, so I'm going to grant you a conditional release. So let me explain to your mother what that means. So ma'am, what that means is he'll get him dressed in his regular clothes. They'll bring him to the courthouse because that's where the conditional release officers are at, downstairs inside the county judge's office. The jail will bring him up here. Usually it's 30 minutes or so roughly before they get him here. Mr. Laster will meet with one of the conditional release officers. They'll go over the conditional release with him. They'll explain to him the rules. They'll give him a copy of all the rules in writing, and then he'll be free to leave. They will drug test him. Mr. Laster, it's not a maybe or a possibility. I'm telling you, you will be drug tested within the next few weeks. It's going to happen, possibly more than once. And the other thing that's going to happen is if you fail it and there's something in your system you don't have a legal prescription for, then the second thing that's going to happen is you're going to go to jail with no bond. So I'm telling you that up front because I want you to know up front. And if you'd rather post a bond and me set you a bond, that's okay. But if you accept the conditional release, you've got to follow those rules or there are consequences. So you need to stay clean and don't be using anything you don't have a valid prescription for. Mr. Laster, we're going to see you at the courthouse probably in about 30 to 40 minutes. And we're also going to give you a notice for your next court date, or I'm going to ask the jail to give you a notice, and that will be for when? December 2nd at 8:30. Corporal, please give him a notice for that date to see Judge Garcia. Ma'am, are you going to be able to pick him up? So your mother says she's got transportation covered. She'll be here to pick you up. Mr. Laster, do you have any questions?
No, sir.
Ma'am, do you have any questions? All right. We'll see you at the courthouse in a little while, Mr. Laster. Thank you for coming, ma'am. Camry Quinn is next. Mr. Quinn, good morning. Mr. Quinn, you're here because you've been accused of one count of battery and one count of aggravated assault with a firearm. Mr. Quinn, I've read the complaint in your case. There is probable cause. I've also looked at your criminal history, and that led me to the Department of Corrections website, which shows that you're apparently on state probation currently. You're still on probation, correct, Mr. Quinn?
Yes, sir.
So, Mr. Quinn, you're entitled to a bond in the new case, but you're not entitled to a bond in the VOP necessarily. So I'm going to listen to the attorneys and see if they have any additional information before I address your bond status. Ms. Harris?
Your Honor, we spoke with the victim this morning and she is fearful for her safety. These were 2 violent felonies, including a firearm. So we would ask that if a bond is set, condition of no firearms, and we would ask for a higher bond in this case, given the nature of the offenses.
Let me ask a question, and it may have just been the battery's a misdemeanor battery, right?
I'm seeing domestic battery.
Yeah, I think it's a first offense though. So it's the warrant says misdemeanor. Now that's not always, the state may choose to charge something else, but right now I'm looking at a misdemeanor domestic battery and a felony ag assault with a firearm. So that it's a little difference in the bond, but I appreciate the information. Mr. McDaniel, anything on behalf of Mr. Quinn?
Your Honor, I think you've got it straight though, but nothing else.
Mr. Quinn, I'm going to set your bond on the misdemeanor battery. Since you're already on probation at $5,000, your bond on the aggravated assault with a firearm will be $10,000 cash or surety. Both of those are cash or surety. Your total bond is $15,000 cash or surety. Your bond has a condition not to possess any firearms, and your bond has a condition to have no contact with the alleged victim at all. Mr. Quinn, don't try to post the bond, because I'm going to do like I do in 99.9% of the cases that people have VOPs. And what I do in those cases, I'm going to hold you 7 days. I'm going to ask Ms. Harris to notify the state probation office of your arrest. Then they'll have 7 days. If they want to seek a warrant from the circuit judge, we'll see if they get one or not. I'll see you in 7 days. If they don't have a warrant, I'm going to release this hold and you'll be free to post a new bond. If they do have a warrant, we'll see if the circuit judge gives you a bond in the VOP. So even though your bond is $15,000 in the new charge, you've got no bond in the VOP case, at least until next week. Do you have any questions, sir?
No, sir.
Have a good day, sir.
You too.
Thank you. Starla Simcoe. Ms. Simcoe, good morning, ma'am. You're here because you've been accused of one count of sale of controlled substance being methamphetamine. Ms. Simcoe, the jail advised me this morning that Corporal Gross told me that you already have a trafficking charge that you have a bond set on. Is that right, ma'am?
Yes, sir.
And it looked like to me it was set at $50,000. You've not been able to post that bond. I'm going to set your bond in this case, ma'am. Let me see if the attorneys have additional information before I set that bond, and we'll try to figure out your court date. Ms. Harris.
Nothing further, Your Honor.
Mr. McDaniel. Okay. Ms. Simcoe, I'm going to set your bond at $25,000 cash or surety on the cell case.
Your Honor. She actually has 3.
Hang on just a second. There's a condition of random urinalysis if you ever post that bond. Corporal, go ahead, please.
She has 3 counts. It's not just one. I'm not sure if it was on the first appearance sheet or not. She has 3 counts of cell.
It's not on the first appearance sheet at all.
Those 3 complaints.
We have 3 complaints, Your Honor, but it's not listed as ×3 on the first appearance sheet.
Well, the problem is that you can't tell if these are 3 complaints or if they're just copies.
There's 3 complaints, Your Honor. Each one has a different date on it.
Top left corner, you'll see the dates of
No,
it.
the top left number is exactly the same, 7/21 to 7/25. Then there's 2 of those. Then there's one that says 8/11 to 8/15, another one that says 8/11 to 8/15. There's 2 of those, and there's a third one that says 9/22 to 9/30. So there's 6 complaints, but there's only actually 3 charges, right? Okay. So Ms. Simcoe, I didn't catch that. I just thought we get multiple copies all the time. I don't know why, but we do. So I just assumed that's what it was. So let me just see if all these are worded the same. The first one I read, there clearly is probable cause on that one. That was the one that allegedly occurred on or about July 21st. The second one allegedly occurred on or about August the 11th. It's a larger amount of money that was supposedly paid for this substance. There is probable cause in that complaint. And the third one was only $25 for methamphetamine that was supposedly bought. There is probable cause. So what that means is you've got 3 charges, not one, and your bond's going to be 25,000 times 3. So your total bond today is $75,000. That's in addition to any other charges that you may have already have bonds on. Ms. Simcoe, you do have a condition of random urinalysis in these cases, if you're ever on bond in these cases. Ms. Simcoe, next I want to try to figure out your court date, ma'am, because I'd like for you to get on the same court date if you've already got one set in the other case. Well,
she's already had an attorney appointed, so it'd be on a pretrial date. So I think
she's already been to an arraignment then.
she's got an attorney appointed to her, so she probably needs to go on this next arraignment docket.
So you're going to have to go on the arraignment docket to get through the attorney appointment process in this case. And when would that be done? I'm going to schedule your court date for December 2nd and see if we can get you an attorney appointed. There's a good chance it'll be the same attorney that was appointed in your other case. Ma'am, do you have any questions?
No, sir.
All right, ma'am. Have a good day.
Thank you.
Yes, ma'am. Deetra Wyrestick.
I say that, I guess, yeah. I could have arraigned her, I guess, but that's all right. That's probably best.
There's no information filed though. I couldn't arraign her. Ms. Wyrestick, good morning. You're here because you've been accused of 1 count of driving while licensed, suspended or revoked knowingly, ma'am. This appears to be a first-degree misdemeanor. Ms. Wyrestick, I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, and we'll see where we go from here.
Your Honor, she lives in Cottondale. I think it's been there about 5 years. We're just asking for some kind of reasonable option for release. License suspended for financial reasons. And, I think she's got to pay about $500 to get her license back. And, so it is what it is.
Was it, I didn't look at the purpose of the reason behind the suspension. Was it unpaid ticket or was it insurance?
Insurance.
Insurance.
Okay. All right. Thank you, Mr. McDaniel. Ms. Harris, anything from the state?
Nothing further.
Ms. Wyrestick, you have nothing for about the last 10 years or so. The problem is that you've been to prison for driving while licensed, suspended or revoked in 2 different counties. So, ma'am, I'm going to set your bond in today's case at the normal misdemeanor bond I set, which is $2,500 cash or surety. You have a condition not to drive a motor vehicle unless you get a valid license. So, ma'am, when
Yes,
you
sir.
post the bond, you'll be released. But you cannot be driving unless you get your license resolved first. If you do get caught driving, that would violate the terms of your bond. Ms. Wyrestick, the other thing we're going to do is I want to ask the jail to give you a notice for your court date. That way we know we know you get it and we don't have to mail you one and hope you get it. The court date for misdemeanor court would be December 1st at 9 a.m. Corporal, if you can give her a notice for that day. Ma'am, you will not get a notice in the mail. The notice they're going to put in your hand will be the only notice you get. You've got to be in court in the Jackson County Courthouse in the misdemeanor courtroom, December 1st at 9 a.m. Ms. Wyrestick, do you have any questions?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. Corporal, that's it as far as my jail list. Did I miss anything, sir?
No, Your Honor, that was everything.
We appreciate it, Corporal. We will see you tomorrow, okay? I mean, actually, we'll see you Monday.
Yes.
Okie dokie, friends. It's the Courtroom Files Live. It is a Super Friday here. Glad to have you all with us. I'd like to direct your attention to the pinned chat. If you are not already signed up for the TCF Discord server, you should go over there. It is free, costs you nothing, but gains you so much. Specifically, what it's going to gain you is notifications every time we post and go live, because you're not going to get that from YouTube right now. You're going to get in at the ground floor. We only spun this thing up a couple weeks ago, so not much going on there yet. Get it for the notifications now. But as we continue to build, there'll be good community action over there. And in the near future, we're going to start doing a post-game show right after this show where we can discuss what we saw, and that is going to happen on Discord. So be sure to check that out. Get over there if you haven't already. Let's go to Texas. We'll say good morning to Judge Stevens.
Yes, and I would do the certifications.
All right. Next, we call 24 CR 2260, the state of Texas versus Taylor Levette Jackson. You are Mr. Jackson?
Yes, sir.
And you were here with Mr. Lang, your attorney, and the state's attorney is here. All right, we are here on an announcement 5. 5 cases total, is that right?
Yes, sir.
Okay, are they all similar allegations?
With the exception of one, one is a unauthorized use of a motor vehicle and the others are ag sexual assault.
It's like 4 cases of sexual assault of a child was carved out of 2 events,
Yes, sir.
December 11th and December 14th.
Right, as juveniles. And then certifications, and some of the announcements have been to retain the certification material. I've talked with Mr. Nelson, and I think we're satisfied that there's a proper certification. If I could have one more announcement to give with Ms. Moore, then we could see where we're headed.
Right. The other case is a separate
Unauthorized use of a motor
unauthorized use of a motor vehicle.
That-
Hold on. Thanks. He was indicted on October 30th of
Yes.
2024. What took so long?
Well, it was a grand jury indictment. Nobody knew the warrant was issued. And when he got arrested for the unauthorized use, that was when he realized that there was even an indictment for something that he did 9 years ago as a juvenile. And so that's how.
Well, they still count
Well,
when they're sexual assaults on children.
yes, but that's how he understood their movement. He did. That's why it's the way it is. That timeless.
Just saying. While I am waiting to receive some information here,
Yes, sir.
each of these are first degree felonies, except for the unauthorized use of a motor vehicle, which is a state jail felony. So you got 4 cases where you're looking at life up at the life in prison on each case. Do you understand how serious this is?
Yes, sir.
4 life sentences, which could be stacked, theoretically. Then the state jail felony carries with it up to 2 years in the state jail. Look at one thing. Brian, how's the family? Everybody well over there? That's the best we can hope for.
Kevin, Shirley's been in her bouts. I've had all the bouts with my in-laws, in and out of the hospital.
The what are the dates on the bonds on the sexual assaults? Does it show? Like, what were the bonds on the sexual assaults? Was that on the same day? Something, You're giving me 9/20/24, but I'm looking at a bond on May of this year on that. Oh, for this unauthorized use of a motor vehicle, I guess, huh?
Yes, sir.
He was arrested 9/20/24 on all of the cases.
On all the cases.
And he bonded out 5/28/25.
Okay, even,
Sorry. I just wanted this last.
it's, he got arrested when they arrested him for the unauthorized use of a motor vehicle.
Yes, sir.
And then those other cases had been pending, and then they all collapsed on it.
And then they took him to a certification hearing prior to getting released.
What are your bonds on these aggravated sexual assaults of a child?
They're very
What are
high.
they?
Yes, sir. They
How
were
much?
100,000 apiece.
Yeah, I'm confirming that, Judge.
Who paid for that?
My father.
You know, this is your responsibility. You understand all of this,
Yes, sir. Yes, sir.
not your daddy's. This is yours responsibility. Welcome to the real world and grown up adulthood. And all of us, when we make a mistake, we've got to handle it responsibly. Are you going to do that?
Yes, sir.
Well, Mr. Lane's a very good lawyer. He can help guide you through this, but these are most serious crimes. Juries in this county deal with them severely.
Judge, incorrect in that the bond is $100,000 on sexual assault cases, and on the unauthorized use, the bond is $6,000.
The one of the conditions of bond is that you cannot have contact with a victim of an offense. And with you, I'm adding a condition of bond. You're not to be around a child without alone, without some kind of chaperone of an adult. You understand?
Yes.
You're talking about children who are 6 and 7 years old. That would be an added condition of bond.
Yes, sir.
One error on these types of cases for a bond, and your bond will be revoked, and you will sit this out in jail until this can get resolved. There's hardly a more serious crime in the penal code than this. You understand?
So,
Okay, how much time, Brian, do you want on an announcement? 5, 6 weeks?
yes, sir.
Is that good? Okay. All right, please get a resetting.
Thank you.
And also you, sir, come on up, you gotta get resetting. And also you nor anyone on your behalf can have any contact with these victims. You understand? You or anyone, if I find out that someone is talking to them or the parents of these, you need my permission. And the lawyers have to do their job in investigating, but I don't want children who are victimized to be re-victimized or or manipulated during an investigation until all of this can get completed. All right, Arnie Koenig.
So we wait for the next contestant. Michelle asks in the chat, what was the crime? Lindsay says, if it's that serious, why is he out on bond? Well, it appears that we have crimes against minors. And why are they out? Because yet again, I question how seriously the court takes these matters. But, you know, we've discussed it time and again, and it just seems to continue to be an issue. Let's get back to Judge.
Which would otherwise be a state jail felony, except you got, well, two other state jail felony convictions. In 2017 and 2021 out of Liberty County, Texas. Does that affect the punishment range on these?
Yes, sir.
To it. So the state jail felony, that would otherwise be up to 2 years in the state jail because of these prior convictions. This kicks up the potential punishment range to what would be a third-degree felony range, up to 10 years in prison. We are all responsible in crimes. When a crime is committed, every person charged with the crime is subject to the result of the circumstances of the crime and criminal history. Those are the two parts of the equation that are part of the criminal system in dispositions of how somebody gets dealt with and the punishment. What are we going to do today, Brian?
Well, we've gone through a couple.
It was an announcement to that for today.
It was an announcement today. I tried to set up.
It's been a year since he was indicted.
Well, I've gone through a couple different prosecutors. At this point, we can set it on.
That's not unusual.
But I tried to give it this gas ball, but if the court, right now.
What do you want to do?
We're at an impasse. Right now, we'll put on the trial.
Sit on trial, right? Sit the trial. That's all language to get.
Well, I like to talk. I'm a talker.
Everybody likes to talk, but you need to say something
I gotta say something.
when you're doing that. Randy Johnson?
Holiday.
Yeah, I'm right in back.
All right. Today, a status hearing is what we had planned. And the defendant, you or Randy James Johnson?
Yes.
Mr. West is here. Mr. McNally is your attorney. You don't object to him being here with you, right? Is that okay? Look, when you come to court, would you wear that at church? Why not?
I'm sorry.
Well, but nonetheless, yeah, leave a shirt in the car or something so that you can put it so it's decent. That's not proper.
Honestly.
You know, and it just shows that this isn't, you don't have much respect for the whole process here. That's what this shows. And you should be, it's your liberty at stake. You're looking at up to 2 years confinement in a state jail. Okay. So he pleaded true back in June of this year. And what did we do on this? Did we just continue him on probation? All right.
Make some progress.
Okay. So on behalf of probation, let's get to the bottom line. Good news or bad news?
Good news.
Okay. That changes the direction we were headed in here this morning. Go ahead.
He has completed one of the courses that he was required to.
How many does he have?
There are two.
When are you going to complete number 2?
I get paid on Thursday and I'm gonna start on it then.
How long does that take?
It is the 32-hour course, so it can take some time. And then there was the theft class, and he did complete that.
I'm sorry.
The theft class, and he did complete that.
Good. What'd you learn?
Yes.
Give me an example.
Like with the theft, what I'm being charged for, like, I could have went in different ways instead of just bringing it to the street. I could have called and involved more people, speak up, said, do different things instead of trying to take it into my own hands and doing it.
I know you're talking about, you use I a lot, but you know, there's a victim here. In crimes, they're victims.
Yes.
And what about that? I mean, do you regret
Yes.
causing harm to someone?
I do.
When it's a theft, generally it's a loss of something of value
Yes.
that they have, that they acquired, that they work for. Just like me grabbing for your wallet and taking it and I say, it's mine now. You'd feel victimized, which you should, because you worked off for it. It's sweat equity that you can't get back. And the sweat equity was in something that you acquire. See, sometimes it's materialistic, sometimes it's there are other forms of reward, but those are things that you can't get back again because you've already put the effort in. You'd have to duplicate it, which we only have about 80 years on the planet. So we don't have time to pay for the same real estate twice. You know what I mean? And that's the way it is for victims. So was there any restitution on this one? I'm always sensitive about that.
Yes. There was restitution.
Is there anything left?
Yes.
I don't like that. You've been on probation now for a year and a half. How much is restitution?
1,500 in total, 1,350 is left.
You only paid $150 in a year and a half?
Wasn't working at first.
How are you now?
I'm working.
Well, how much can you pay toward this I wanted to go for restitution, please, first, and then we'll catch up on the other stuff. I can shorten probation for good behavior, but good behavior includes paying victims back. It would cost you less if you get it done quickly. Then we could, all things being the same, if you're doing fine, then I shorten it I shorten probations I can do it in a third of the time. Like for 5 years, a year and 2/3, I can shorten it, which in your case would be almost there if you were doing everything fine. But until you can pay this victim off and take care of the other obligations on probation, then you're going to be dealing with me. What else do we need to do today? I want to know on the restitution, how much can you pay back a month? How much can you pay a month toward restitution? Right now?
When I get paid Thursday, I will be able to.
No, I'm talking about long term, not just, you've got a regular job, right?
Yes, sir.
Oh, okay, I'm talking about how much can you pay a month? So restitution and then pay your bills.
At least trying to balance everything, I can do 3.
Sir,
300. Do 300. They just.
Okay, well, here's what I'm gonna do is order you to pay 200.
Yes.
Meet that goal. Because, and what's left?
1,350.
All right, so that's 6.5 months.
Yes.
State champion in number sense, right? Should have been an engineer, but
Not
no,
good at math,
I went into
I'm a
law.
lawyer.
Okay. So I want to review this in 4 months. See how he's doing? Is that good? Anything you need to know about or ask so that you can complete your probation successfully? Okay, well, just get it done. Okay, Smith. Any problems come up? She's your guiding, you get lost in the woods. A lot of people do on probation. They're about to make the wrong choice. She's your lifeline. You call her, you get advice. She'll guide you out of the problem. Don't delay if there's an issue. Resolve it. Thank you.
I don't know how I.
Shane Myers.
I'm
Okay.
gonna give you a copy.
Shane Myers.
And that's what it said.
I believe all of the cases that we said, Your Honor.
St. Myers has been reset according to my boss. And that's 3 cases. It's reset for what, though? It's
It's located on the docket, but there's a third amended TRP that's on the way, so.
okay. When did we reset it to? Because I don't want to go when we modify, that means something bad happened that we need to address. Norman Marshall is next.
The first week of January, the defendant is in custody though.
Okay. The attorney knows that. Reagan, I guess, knows that.
Yes, correct.
Are you Norman Marshall?
Yes, sir.
This is about restitution. Who's on?
I filed a motion to dismiss.
Oh, you got it? Oh, okay.
Yeah, here, Mr. Patches said.
You paid it off?
It was paid.
Yes, sir. The ticket,
Good for you.
receipts right here, you can see it.
No, your word's good enough for me, sir.
Thank you.
And I got a motion that's right here to dismiss for fixing the mess. That case is gone. It's dismissed. Go and do well.
Do I get a piece of paper saying that?
Well, yeah, we can get you a parting gift like that, no problem.
Okay.
The best thing, though, is she's not, the best thing, we're gonna have to get it through the district clerk.
You're gonna mail it? Will you mail me something or?
We won't mail it.
She's gotta prepare it first,
Right, I understand.
and it takes a day.
So it goes over to the district clerk's office. That's where you can get a copy. So
Will they email me a copy or something? I'm 5 hours away.
Yeah, we can take care of
Or
it.
I can email it to James or something?
you can speak to the ladies across the way.
Okay.
And they can tell you how that works.
Okay, James can probably take care of it for
If
me.
there's a problem, call us, and then you'll
Yes.
get something wired through your somehow. You don't need to
Okay.
drive it.
Right.
Yes, sir.
Thank you, Joe.
Okay, yes, sir. Rebecca McWhorter,
That was pretty sad.
how are we gonna get things done? If we reset them? I'm just asking. Nakia Washington? That's reset?
No, that's fine. Your Honor, Mr. Rank's listed on there, but I've held. Okay. So I'm also. I would say I'm playing Mr. Riddick, but I'm actually playing this.
Good morning. I'm fine.
Yeah. Not falling on the chair. You know.
Hi, you're Nakia Washington?
Yes, sir.
And here with Mr. West, your attorney today, the state's attorney and the probation officers here. We have a first amended motion to revoke probation that had been filed a year ago, correct? Is that the most recent thing?
Yes, Your Honor. I believe so.
And something doesn't make any sense. On first amendment motion, I've got that pleas of true were entered on paragraphs 2 and 3.
And 8, I believe.
Hold on. But I have that dated 6/17/21.
Should have been 6/17/25.
25 of it. Okay. Okay. And I'm going, why in the world, what's 21 all about? And that's when the motion was filed on 6/21, the original motion. And we must have been talking about that when I was doing the writing. So on 6/17/25. Correct. Sorry, Judge. All right. And, okay, on the next page, I've got 6/17/25. Now 21 got on mine. And these were a specimen result, and it came back with marijuana, and then failing to report online. So how are we doing, Ms. Martinez?
Your Honor, she has been reporting and she paid all of her restitution off.
Oh, that's great. So she's been on probation since when? 19? Since April 19? And that was $2,033 restitution, correct? And this has been a deferred or unadjudicated probation, correct? The whole time? We've had her on probation for 5 years originally. 5 years and 5 years. So what can we do today? What do you think?
Well,
Don't help her. She's is it?
she's good. Yes, sir.
Okay. Any objection to me dismissing this case or her moving on with her life without a conviction?
You do without my signature,
Then
yeah.
so it shall be done. Okay. Good luck. Good luck and good work. Thank you.
I'll need an NPR this.
So I point out in the chat that this defendant was tiny because a very, very petite woman. And Ashley responds, "I'm tiny too. Tiny people can get into all sorts of things." Is that Ashley's evil thought of the day? Just asking. Let's, where do we want to go? What do we want to do? Let's check in on Judge Glazer. Let's see what's going on there. See how it's going this morning for her.
Sir, stay away from the Whole Food store at 2910 Biscayne Boulevard in Miami, Florida. You're not allowed to go to that location. You must stay away from there, sir. He's 71. Well, that's what his page is. What do you want your bonds at?
So it's not food, it's alcohol, right? 10 bottles of champagne. $1,500.
I'll set your bonds at $1,500. Have a nice day. Stay away from Whole Foods. I give you a little break in the bonds. Mr. Alexander, if you have a case, you look on the calendar, tell them what page it's on, and then you can pull it out of turn, okay? Will you come and take it out? Tell the clerk to take it out. Harold Ortiz, we got to tell corrections. Mr. Ortiz. Good morning, sir. English okay or Spanish?
English is fine.
Sir, good morning. You were arrested for driving with a suspended license, third or subsequent conviction. I will appoint the public defender's office for you.
John, there find PC for a permanent revocation. If your honor looks at the defendant's priors, I see.
There's probable cause for driving with a license permanently revoked. Would you consider pretrial services for Mr. Ortiz, Judge? I don't think so. He almost ran down some pedestrians.
Right, he's got multiple felony convictions for driving without a license.
I had signed up.
On $2,500. Good day, sir. No driving unless you have a valid license. Robert Jackson, page 10. Good morning, sir. You were arrested for possession of cocaine. I will appoint the public defender's office for you. You had 20. Was it intent to sell 22 baggies with cocaine? State.
Yeah. It looks like intent.
There's probable cause for possession with intent to sell cocaine. Your bond is $7,500. Next, Marlon Murphy, page 11. Good morning, sir. You were arrested for possession of cocaine. I will appoint the public defender's office for you. There's probable cause. Is he eligible for any TAP maybe or a program? Do you have a place to stay, sir?
I would have, you find no probable cause. They're just saying that they find a loose piece of crack cocaine in the same area.
I'm giving him a program. There's probable cause. Do we want TAP or pretrial? Not eligible for pretrial. He's getting TAP alternate bond $1,000.
He has a,
They always said it's not eligible for pretrial. I'm giving him TAP. Does he have an address?
Yes.
And then you can get out of jail for free with TAP, sir. Have a nice day. Next, we have on page 11, Roy Barnhill. This is the slowest calendar today. I feel like I've been here forever.
It's only 11 though. We're not doing so bad.
Jeez. Good morning, Mr. Barnhill. You were arrested for petty theft, 2 or more convictions. I will appoint the public defender's office for you. So it's alleged he's stealing, what else? Walt power tools. That's what everybody takes from Home Depot. He has a conviction for petty theft from July, 28 days. Sir, you are ordered to stay away from the Home Depot store at 19400 Southwest 106th Avenue in Miami, Florida. You are not allowed to go to that location. You must stay away from there, sir. I'm setting a bond. I'll set it at $1,500 because you got recent convictions. He has one from July, one from May. Maybe I shouldn't lower it. State, are you okay if I lower the bond to $1,500?
Judge, would you consider a program for Mr. Barnhill? He just got a pretty good job.
Like 1,500 is okay.
To lose it.
For 4 months.
He has 2 recent convictions. Plus last year, $1,500. I lowered
That if he loses his job, then he also might lose his place when he's finally getting.
Well, he may be facing prison sentence. I don't know, but he's presumed not guilty, but there's probable cause. He has a conviction from July and one from May, both for petty thefts. Stay out of the Home Depot. Alex Argueta. Page 11. Good morning, Mr. Argueta. You were arrested for child neglect and burglary with an assault or battery with prejudice. This is a case from November 6th. I will appoint the public defender's office for you. Please give me a moment to review the arrest affidavit for probable cause.
Judge Glazer putting a lot of thought into this one. Well, that's good. That's what they're supposed to do. Happy Friday, everybody. Welcome again to the Courtroom Files Live. It's good to have you all here. I put this in the chat, but just so everybody's aware, game night will remain on hiatus at least for a couple more weeks, so we will not have that this Saturday, even though I'm back, because something has to give in my schedule at the moment, so that's going to give for a couple weeks. All right, looks like she's figured stuff out. Let's go back to Judge.
Gone since the date on the arrest form. He's already been into the court system to go through legal proceedings in the family court regarding the child custody matter.
Okay.
Judge, I would ask Your Honor would consider a bond for him.
I don't know if it's child abuse or child neglect. Yeah, she's charged properly with child neglect, pardon me. I'm giving him a bond. It's going to be no bond. I'm granting the state's motion for pretrial detention pending final hearing. Your order to stay away from Haiti Bustamante, the alleged victim, that's the mother of the child. No contact. She should have been ordered to stay away from her father because he punched him when he's in the car. He punched him and gave him a bump on his head. Where's my other non-domestic stay away order?
There's only one victim on the back of the A form.
No contact with Haiti Bustamante, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir?
Yes, ma'am.
So I think it's really good that you went over to family court and filed a petition to determine paternity. So just so you know, we're all human. Everybody makes mistakes, okay? And you made a big mistake by what's alleged here, but I'm required by law to hold you with no bond.
Judge, you do have the discretion to
This is one where I
set a bond, Judge.
I'm not so
bad. It just happens in a car.
It happened in a car. It was very violent. And it's pulling a child through a car. I'm not trying to take the child from the mother and hitting the mother and the father. I'm not giving him. I'm holding him with no bond and granting the state's motion. The judge on Monday revisit it. There's going to be a hearing Monday, and that judge can give him house arrest or set a final hearing.
Judge, he has no criminal history, Judge. I would ask Your Honor if you would set a bond or even an ankle monitor so you know he's apart from her.
I can't do that. I'm sorry. I recognize he's young. He made a mistake, but I can't have to hold him no bond unless the state's going to agree, and I doubt they will because she never agrees when she files a motion.
No. Unless I hear from the victim, no.
The victim's not here to give her input either, so I'll set it Monday, and hopefully maybe the state will have a chance to reach out to the victim. It's no count one to child neglect. I'll set it at $1,000. Count two, the burglary and assault or battery. There's no prejudice. It's no bond. Good luck to you, sir.
Judge, with regard to the stay away order, since they're going to be in family court proceedings, which have already been filed, I would ask at least
you can attend all. I'm not sure.
Time, Judge.
Let me just see.
It's.
Those are usually done on Zoom. I'll put attendance at a family court hearing regarding custody will not be a violation of the court's order.
Judge, I just get confused by these cases because there's other cases that come before this court every day where there's allegations of more severe violence levels than a punch, and they get a bond all the time or bond.
Everything's different, and I look at case by case, and I don't trust
somebody without a record, Judge.
Miss Corey,
not a stranger. I'm just asking for a bond.
I understand. I don't feel comfortable doing that. Not based on what I read here. It was really violent. They're yanking a child through a window, hitting the mother and hitting her father who's driving. It's very violent. I think she should be held with no bond.
There's just other cases that have higher levels of violence and they're getting bonds here.
I don't know. I look at each case by case, and the division judge.
We just had an attempted murder here a few days ago, Judge. He got a bond plus house arrest.
Which one is that?
That was Mr. Brown,
Who's Mr. Brown?
the football player that was here.
There was probable cause for an aggravated assault with a deadly weapon. That's not an.
That was a fight, judge, which is a lot more dangerous than a fight, judge, with unknown.
That's a third degree felony. This is a first degree life felony. It's a different charge. I have to, when you enter a vehicle, which is not yours and you don't have permission and you commit a crime therein, that is a first degree felony, burglary with an assault or battery. And he batters the people inside.
The court would find probable cause for burglary, assault, and battery, but essentially the violence level is a punch.
The victim had a bump on his head and he's yanking a child. So I don't know the laws. I'm not always happy with the way the law is written. I just try and follow it. There's probable cause for first degree felony. It needs to go before the division judge on Monday. That judge will set a final hearing on the state's motion. For pretrial detention, that judge can also decide on Monday to give him a bond, but I'm not doing that. If you're not happy with the court's ruling, please file an appeal. Maybe they'll change the law, but I can't. That's not my job to change the law.
So I gotta say, personally, I'm in support of what the defense attorney was saying right there. I'm also in support of what the judge said and the fact that she can't change the law. But we did see that. I mean, we opened up the other day with the Antonio Brown case right in this court where he ran to Dubai to avoid charges of attempted murder. Comes back because he's extradited into New York and then extradited into Florida, and he gets a $25,000 bond and house arrest, where this guy is going to get no bond. Now, I'm not saying he should have a bond. He should probably sit based on the facts as we heard them. But again, how is it that a guy who is accused of attempted murder and runs halfway across the globe to avoid it get a bond? Well, this person does not. So yeah, there is an imbalance there, and I would tend to agree with the defense attorney in this case. I also get what the judge is saying, but it's messed up, it's broken, and at some point somebody's got to fix it. Yeah, Mr. Brown was Antonio Brown. We covered that the other day. You might have missed that show, Lindsay, but we cold opened right into that case where he was in front of Judge Glazer for his bond. He had already pleaded guilty the prior day pleaded not guilty, rather, the prior day to this charge, and then he appeared in front of her for the bond hearing. So, yeah. I don't know. Doesn't make sense to me, but, maybe it's just me. Again, but I'm not saying this guy should get out. I don't think either one of them should. I mean, why does the guy who runs halfway across the globe get a bond? Because he's famous? Why does that happen? It doesn't make sense. Anywho, let's change it up. Let's go to Ohio, Judge Vincent Collada. Let's see what's going on there.
All right, first case is 25 CR 1492, State of Ohio versus Taryn Johnson. Ms. Smith?
Thank you, Your Honor. On behalf of Mr. Johnson is in receipt of his indictment. He has been for more than 24 hours, waives any defects in time, manner, place, or service. He is aware of the offenses for which he's charged and waives reading of the indictment as well as advisement of penalties, enters a plea of not guilty, and asks the court set the matter for a pretrial. Mr. Johnson wanted to execute his right to an in-court, but does not wish to be heard on bond.
He does not want to be heard on bond? So, Mr. Johnson, you received a copy of your indictment?
Yes, sir.
You had a chance to look that over?
Yes, sir.
You do have the right to have me read it too if you want. Would you like me to read it too, or you can waive that if you want?
Oh, thank you.
So then, as to each of the 4 counts in this indictment, what is your plea to those 4 counts?
Not guilty.
All right, I'll enter a plea of not guilty. And bond was previously set at what? Whose case?
Your Honor, the bond was set at the municipal court, $10,000 cash or surety with conditions of GPS and no firearms.
All right, well, I'll set bond at $10,000 cash surety. I'm not going to put a GPS condition on it. So just $10,000 cash surety. Was it 10% or not?
Just cash surety.
$10,000 cash surety. All right, thank you. Okay, call next case. Give me 1 second, please.
Yes, Your Honor.
Ms. Smith, real quick, I don't know if Mr. Johnson was intending on posting or not, but he needs to fill this out if it's ever gonna, or you have one? That was good. So you have the conditions from there, Sam? All right, then take that with that. Thank you. All right. Next case, State of Ohio versus Nakia Gray. I pronounced that correctly? Nakia?
Yeah.
25 CR 1410. Ms. Smith, I'll hear from you at first.
Thank you, Your Honor. On behalf of Ms. Gray, Ms. Gray is in receipt of her indictment. She's had it for more than 24 hours and waives any defects in time, manner, or place of service. She further waives reading of the indictment and advisement as to penalties, respectfully enters a plea of not guilty, and asks to be heard on bond.
Thank you. So, Ms. Gray, you received a copy of the indictment?
Yes.
Excuse me, when did you get that? If you remember.
I got it this past Wednesday.
Okay, so a couple days ago at least?
Yes.
Okay. You do have the right to have me read it to you, as I briefly just explained to the other gentleman, but you can also waive that. Would you like me to read it to you at this time, or do you want to waive that?
Waive it.
All right. Then in regards to each of the 4 counts in your indictment, what is your plea to each of those 4 counts?
Not guilty.
Enter a plea of not guilty. As to bond, let me hear from the state first as to what they're seeking here. Mr. DePiro.
Your Honor, thank you, Your Honor. I have had a conversation with Ms. Smith, also the victim in this matter. These charges stem from a relationship that the defendant has with her son's father. The defendant has a 3-year-old child with a man named James Moss, who's the victim in this case. The bond was set at the municipal court at $50,000 cash surety with conditions of no contact with the victim or Bishop Park Apartments and GPS. The bind-over charges are more serious than what was actually indicted. What the bind-over was a menacing by stalking against Mr. Moss, also a trespass in a habitation.
Against Mr.
Moss being the victim.
Oh, not against him, but I mean, all right.
He's the victim.
Gotcha.
And the F4 trespass in a habitation also was his apartment. Turns out the indictment's a lot different here. We have a criminal damaging. This is the defendant kicking the defendant's door, broke the frame. It was out of frustration, not an attempt to enter his apartment. But she did try to enter his apartment on another day here. That's the attempted trespass in a habitation on the indictment. In speaking with the defendant is 24 years old. She has 1 prior misdemeanor disorderly conduct reduction in the municipal court, which was from June of this year. That also involved Mr. Moss. Other than that, she has no record. Mr. Moss was not scared of the defendant. He has no objection to her bond being reduced even to a known recognizance. He doesn't even think GPS is appropriate. He doesn't want her to come by his apartment anymore.
So why are we here right now for
Because it was a $50,000 cash surety bond, and I didn't feel that it was appropriate for us to just unilaterally change it and present you with a form to that effect, Your Honor. I wanted,
That's a first.
Well, if I was the judge, that's what I'd want. So that's why. So we have an agreement here in terms of the state would not object to an own recognizance bond in this matter with the conditions of no contact
with Bishop Park Apartments or the defendant
or
the
Moss.
victim.
But Mr. Moss did say that he does want to be able to communicate over the phone about the child.
Well,
but I told him
that's going to be too much of a. That's going to have to wait until this gets resolved.
Yes, Your Honor. So
I'm assuming you're good with that bond?
Yes, we have no objection to the owner cognizance bond or the no contact order.
Well, I'm gonna set bond then, reset bond at the defendant's owner cognizance with the condition that you have no contact with Bishop Park Apartments and no contact with Mr. Moss. And that means you can't contact him about your child either. And I know that may be an issue now, but I can't say except for these circumstances, because then it can never be monitored or policed. So while this is pending, that's gonna have to be the rule. You understand that?
Yes.
And we've reduced your bond substantially, but if you violate that, I'm not going to hesitate to revoke it. If we find out that you reached out to him, and even if you come up and say, well, I found out something about my daughter and I had to talk to him, that's not going to be an excuse. There's no excuses here. You understand that?
Yes.
All right. And then bond will be reset at defendant's owner cognizance with the condition of no contact at Bishop Park Apartments and no contact with the victim, Mr. Moss. She fill out paperwork? You got one filled out there for
We
her?
have conditions of bond. We do not have the owner cognizance paperwork.
I have OR paperwork, Your Honor. I will give that to Ms. Smith right now.
Stan, can you witness? Right. So the important
Are you
thing to
gonna
know
witness,
about
Stan?
this is when you're released on an owner cognizance bond, even though you don't have to post any money, if you fail to appear because it was on your words, it's a felony as a 4th degree. So you'd actually be in more trouble if you didn't come to court than you could be for what you're charged with here, okay? So as long as you understand that, sign your name.
He's gonna do it right here. He's gonna fill out the paper stuff.
Sorry.
You're good.
Did I fill out the rest?
Smith, you said you had conditions of bond form filled out already?
I do as well as the trial waiver.
What county is Bedford? Is that Cuyahoga County?
That is.
I'm gonna put that up here too then. That's where you're gonna be residing in Cuyahoga, in Bedford?
Yes.
Yes.
So this OR bond, Ms. Gray, means you have to show up at all future court dates. And if you fail to appear at a future court date, that's a separate felony that you can be prosecuted for. It's actually more serious than anything you're charged with here right now. And you can get up to 18 months in prison on that, which could be consecutive to anything that could happen with any of these charges. So it's obviously, or at least a felony. So it's obviously important you show up at all your future court dates. You understand that?
Yes.
All right. All right. Very good. You can take off, Rob, if you want.
What's that, Judge?
You can take off if you want.
Thank you, Your Honor.
All right, I've got my eyes on about 14 different courtrooms at the moment, dancing around a lot of landlord-tenant this morning, as is often the case on a Friday. So being selective about what we're showing. But let's go back to Texas right now, back to Judge Stevens.
Right? Which is a little better than the 75% national rate. A lot better, actually. Must be some great probation officers that are working for us here in this county. That's all I can say. All right, here we are on Mr. Coward. And he was on probation. He's been on probation a while too, since 2019. And this was a theft case. And there was restitution at the beginning of $4,280. Well, I hope that is dwindled to nothing.
Mr. Cowart was actually incarcerated for the first about 5 years of probation. He was actually paroled in April of 2023 for a brief moment.
What was he in prison for? It must be another case.
It was a Orange County and Hardin County case, I believe. And then
Of what? What was the crime?
Failure to register.
As a sex offender? Okay. What else?
he he had a blue warrant issued and his parole was revoked and he went back to prison for that. And then we had a motion to revoke on him after he was completed that sentence. He was released and opted to not comply back in 2023. Once he completed his sentence in TDCJ, he was served our warrant, which brought him into our custody.
Okay.
He had sent correspondence to the court requesting revocation to run those cases concurrent. At that point in time,
You have restitution.
Yes, you opted to allow him the opportunity to perform on probation because of the restitution. Mr. Cowart has been reporting to me directly since you released him from custody. He has paid $711 toward his restitution. He does have some medical issues. He completed a substance abuse evaluation because during those meetings, he has tested positive on 2 occasions, which we were able to obtain some medical records in which he was prescribed a medication that would cause a false positive of opiate, but not for the methamphetamine. And then he also had tested negative and then followed it up with a positive for methadone. Mr. Cowart and I have had many discussions about those uses in which he does admit to those drug usage. And we're here today for the follow-up review of the motion to revoke.
And this motion to revoke probation was motion filed August of 23, over 2 years ago. But we ended up having a final hearing on it June this year, where you pleaded true to failing to report to the probation office, and it looks like on a couple of different occasions, and the court continued you on this probation. And in all cases of theft related matters where there is a loss to the victim, unlike if you broke their arm, you can't unbreak it, but you can pay people back. So there's a method. The only problem is the longer you pay them back, under the law, unlike this federal system where they compound interest for delay of repayment on fees and costs and restitution. Here in the state, it is not interest based, so it's dollar for dollar. If you are in this, like in this case, it's been 6 years since this event. According to the indictment, this happened in September of 2019, and we're still paying these people back. And you really hadn't paid, but how much?
$711
Out of
$4,280.12.
Okay, that's 1/6. That's 16%. That's it.
So it's incorporated, so.
I understand, but you're not incarcerated now.
Yes.
How long have you been a free man? Don't look at him.
Probably 6, 7 months, I'm not.
You got a job now?
Walking on, yes.
What are you doing?
Whatever I can.
Okay. What are you trying to do? I mean, what skills do you have that you can market?
Well, I was bad with this scrapping sometimes. Sometimes I do some house framing. Sometimes I do tree work, and it just really depends.
Yes, sir. Okay, well, there's a lot of building going on in the area. Maybe you can hook up with somebody for regular business. Are you good at what you do?
got.
You're hesitating. Most people jump right out with it, you bet.
I've got a lot of medical issues that keep me from being, peak performance, so.
Right. This probation, even though you do everything great, this probation is going to continue as long as it takes to get the people paid back.
I can actually pay them back today with the help of my brother and what I have established. It can be paid today.
The whole balance?
Yes, sir, but my brother is not willing to go there, not to have an opportunity to go back to prison. So it just didn't make no sense to him. I understand his point and not be able.
Okay, hold on for a second. Here's another thing that this court, you don't hold me hostage.
No.
You don't negotiate with me.
No,
That's not these are the negotiators, not me.
Yes.
I just make the rulings.
Okay.
And anybody who says, look, if you don't do this, then this is what's gonna happen, Judge. No, that doesn't work with me.
Yeah.
I don't tolerate that. Everything is a leap of faith, but it's the right thing to do, and it's what you're obligated to do. And I will promise that I will do what it takes to be fair and impartial. But you don't say, here's the deal. Somebody tried that earlier this week. And I shut that down pretty quickly, because that's not the way you deal with a judge. It's a leap of faith, but it's the right thing to do. And I've been doing this long enough. People know what I'm going to do. But handle it. You get rewarded by getting victims paid back. Period. That's what I've always said. I'm not going to change that. But you don't make a deal with it. It's a leap of faith. So what else are he's been on this now for 6 years. What else? Let's say restitution is paid back. What else are we looking at here that we need him to continue to perform on probation for? Gina?
Well, Your Honor,
you're an expert. Whatever you say, she's one of the best in the business. So she's got she knows the right answers on this, and that's why I rely on this probation office, because I trust what they do. So where are we? He pays the restitution. What other obligations does he have? He's got, of course, a period of time still left on the total probation, but we shorten probations when it's worthy. What else does he need to, what other obligations does he have left to perform?
Your Honor, the concern obviously is going to be the substance abuse. We did complete a substance abuse evaluation in which a recommendation was made for special needs safety. However, because of the fact he is a registered sex offender, he's ineligible for that placement. We have the option of ISF. Even I would ask the court, because of the amount of restitution that is owed, Mr. Cowart does actually live in Vidor, but that we asked the court to make him report directly to Jefferson County if they're willing to continue him on supervision. That way we have a closer eye and to ensure that our restitution is paid to our victims, as well as we could possibly include JCDI, but then JCDI puts a burden of an additional financial burden along with transportation burden.
Yeah, I'm not applying for that, right?
Or we can just continue to monitor the substance abuse usage with putting him on colors, or we could just monitor him with a monthly drug test. We have options.
That's the problem. It's obvious what we're talking about here. We're more concerned about you falling backwards on the drug situation, and monitoring, keeping a close eye is a good deterrent, because shame on you if you fail. But you've got to realize this is in your best interest. This is only good for you, not bad.
And Your Honor, the other thing that he had as a special condition would be the community service. But I do have medical records from his current physician that is prescribing the medications out of Houston that could possibly result in a waiver of the community service because of medical.
Okay, see, we're looking for things to reward you for. My advice, if restitution could get paid back, that makes a big difference where this heads. And also, there might be a method where if we need to continue you on probation, it's less high maintenance. It's more of a relaxed form of probation if we can trust you. But it's obvious that there's going to be, and you got to look at this. You got to realize it. We will continue to test, which is a deterrent. Shame on you if you positive test, but that's what it has to be. And you can't say shucks because it's our test. We're paying for it, really, but it's your best interest. We want to make sure if you're falling backwards on drugs that we catch it fast. But it's your choice. You do the right choice. You shouldn't have anything to worry about. You make the right choice. So what are you going to do? We're going to right now. We're going to continue for the time being you on probation. I want to review it in 6 months, though, how we're doing. But once again, if restitution can get, if you're able to have resources to pay this restitution, I'm telling you, everybody knows that goes a long way with me. The quicker they get paid back, the quicker I'm happy, and I will reward. I always do. And you may have to continue on probation for a while longer, but it will be a more relaxed form of probation that if we can trust.
Are we going to order him to report to Jefferson County directly instead of, was he reporting Orange County?
No,
Yes.
he's been reporting directly to us because of
I think it's probably closer to him here than it is over to Orange County, to Orange. So why don't we do that? That will save you a little gas anyway. Report directly here to Jeannie and the probation office, and get this. I want to know when this restitution gets paid, so I can look at relaxing other kinds of terms of probation that are unnecessary, that are normal, but they're unnecessary so that you're more free to work and be independent. Okay. Let me know. Thanks.
Yes, sir.
Right. 6. Leslie Kettery.
All right, friends, let's try something new. It's a Friday. Why not? This will be Judge Jeremy Darnell Bowie. This is the 50th District Court in Pontiac, Michigan. We've never gone to this judge before. I'm pretty sure this is like a preliminary exam that they're going to do, but let's check it out and try something new today.
You start with counts 1, 2, and 3, criminal sexual conduct, first degree, person under 13, defendant 17 years or older. The first 2 counts. Count 3 is child sexual abusive activity aggravated, and counts 4 and 5 are child sexual abusive material aggravated possession. Appears in the record.
Good morning, Your Honor. Dylan Salvi, appearing on behalf of the.
Marcia does not appearing on behalf of the defendant, Your Honor. And as I asked prior to starting, if it is possible for the defendant to have one hand release whatever his writing hand is, I have paper and a pen for him that he has.
All right, I'll leave that up to the guards, the deputy, so they feel comfortable. Yeah. You see, you're the list, state your name for the record.
What do you mean, the warrant, if you're the.
Okay, we're here for a preliminary examination. Are we proceeding?
My knowledge, yes.
Yes, Your Honor. And for the record, the defendant requested his written discovery. I did deliver that to the jail in 3 separate packets because of its length, and he had indicated to me in a visit that he received it. You have that and received that, right?
You have to say yes or no in court, sir.
Yes.
Okay. All right, any preliminary matters before we start taking testimony?
Just to the judge, first, please will do for mutual sequestration of witnesses with the introduction of my officer in charge, both of them are all in here. I have the third witnesses and all that. I believe that the defendant's family, members of his family are in the courtroom. I would ask them to yes.
All right, so there's a mutual order of sequestration. If you remain in this courtroom and this case goes to Oakland County Circuit Court, you will be barred from testifying in trial. So there's two individuals in the back. Sir, in the red shirt with the vest, what is your name? I'm sorry, you have to stand up and say that again. Kenneth Simpson? Yeah. All right, if you remain in this court and you hear testimony, you cannot testify in circuit court. Ma'am in the front row, would you please rise and state your name? All right, once again, if you hear testimony, you feel like you can help your son in this case, at circuit court, you can't take the stand, so I'll let Ms. Kazamaka make that determination, but your names are here for the record, and it will be sent to circuit court.
You understand what that means, that if there were a trial in this case, you would not be able to testify in that trial at the circuit court level if you are in the courtroom. When testimonies.
We're not trying to be hostile, we're letting you know, so if it goes to trial and you try to testify over there, you can't get mad at Ms. Kazamaka, okay? So I'm just letting you know, but you can remain here, but that's, you've been notified. So, we can proceed now.
Thanks, Judge. Other than that, people intend to admit 5 video exhibits today. All 5 accused are going to be considered child sexual abuse material. They are extremely protective. For the admission and publication of these to the court's consideration, I've gotten on a flash drive with my OIC. We've got a separate computer in possession of my OIC. As far as how to publish those to the court, would you prefer that we approach and show you on this computer, or try to portray it on the big screen so that the defendant can also see it? Because I want to make sure that he also knows what these exhibits are.
All right.
But I'll defer to the court's judgment on how to publish these extremely graphic videos to the court.
All right.
And then, of course, if there are witnesses here, if they are going to be on the big screen, or be concerned that they not be here when videos are shown because of the sexually abusive material.
I think they should step out, to be honest, but I'm not gonna. I think I was perfectly clear about the sequestration order. I think you could approach and we'll turn it to where he can see it as well, or you can show him first and then show me.
Okay.
Yeah. We don't need to publicize it.
All right.
Yeah, yes, that's fine.
Okay, thank you, Judge. With that, people don't have any additional preliminary matters.
Okay. Any on behalf of the defense?
No, yeah.
All right, call your first witness.
Thanks. People call Detective Anthony Knifer. Yeah, you're gonna take on that. Just don't reach one. Yep.
Swear or affirm something to the pains and of perjury, testimony give this perjury the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, you may be seated and chair. Remember your ready.
Thank you, Your Honor. Good morning, sir. Please state your first and last name, spell them for the record.
Anthony Nyberg, Anthony. Nyberg is Nyberg.
Thank you, sir. How are you presently employed?
I'm a detective sergeant with the Michigan State Police.
How long have you worked for the Michigan State Police?
Approximately 6 years.
And how long have you worked in your present role?
I'm currently assigned to our computer crimes unit and internet crimes against children task force. I've been there for approximately 2.5 years.
And what is your exact title?
Title, you said?
Yes.
Just detective sergeant, and I serve as the team leader for the team.
Okay. Now, working in that unit, what are your duties?
Main job responsibilities include conducting criminal investigations related to the sexual exploitation of children.
Have you received specialized training in the area of forensic examination of electronic devices?
Yes, I have.
And have you received specialized training in proper management and electronic evidence?
Yes, I have.
Can you describe the type of training that you've received in those areas?
Yes, I've received several hours of training through Celebrite and Magnet Forensics, or 2 forensic software companies that the Michigan State Police uses. Through them, I've earned 4 certifications. I'm a Celebrite certified operator and a Celebrite certified physical analyzer, meaning I just took a course with them, passed the test, and I'm certified to use their programs. Along with Magnet Forensics, I'm a Magnet certified forensic examiner as well as a Magnet certified cloud examiner. On top of those, I've taken several courses relating to digital forensics to the National White Collar Crime Center and the National Criminal Justice Training Center related to the proper seizure, transport, and storage of electronic devices, as well as the proper extractions and examination of digital evidence.
Now, some of those softwares like Magnet and Cellbrite, what are those used for?
They are used for either the extraction or the examination of forensic evidence or digital forensic evidence.
Okay, so you've been trained in how to use those software programs as part of your investigation.
Correct. I've been trained and certified in the use.
Have you also received specialized training in the investigation of crimes related to child exploitation?
Yes, I have.
And what training or experience do you have?
I've had specific training on sexual assault investigations and child abuse investigations. On top of that, I've received training from the Prosecuting Attorneys Association of Michigan related to multi-jurisdictional teams investigating child abuse, as well as forensic interview and training through them. I've had training on undercover chat operations, which I've participated in several undercover chat operations looking for individuals meeting minors for sexual purposes. I've also had specialized training from a licensed pediatrician on an age approximation of children depicted in child sexual abuse material.
And I'm going to interrupt you briefly. What does that mean?
Can you clarify which part?
The training on age approximation.
Yes, so to determine the approximate age of someone depicted in a file, we were taught the different stages of puberty and development growth of individuals to try to pinpoint which stage of puberty someone is in to better give an estimate of their age.
Thank you, Detective. Now, when you are investigating crimes involving child sexually abusive material, I guess first I'll ask, what is child sexually abusive material?
It's the depiction of anyone under the age of 18, not depicted in either some type of media or video file, in some type of sexual explicit act.
Is it fair to say that like a colloquial term for that would be like child pornography?
Correct.
So we'll use the term CSAM throughout the rest of this exam, if that's okay.
Yes, that's fine.
The acronym for child sexually abusive material. When you are investigating crimes involving CSAM, how are you usually brought into the investigation division?
Majority of our cases start from the National Center for Missing and Exploited Children. They receive tips under federal law. Electronic service providers and internet service providers have to report all instances of child exploitation to NCMEC. They take that information and pass it along to the proper authority. We receive tips from NCMEC from several different electronic service providers, and then we begin our investigations that way. That's how we receive majority of our cases. We do get some calls from the public, and we do some proactive investigations, including undercover chats, as well as investigations on peer-to-peer sharing networks.
Okay, so it sounds like these tips are almost like the 911, where they are provided to you that that's the start of your investigation.
Correct.
During the course of your investigation in these kinds of cases, what sort of tools or procedures do you use to identify a suspect?
First step is usually to identify the account holder or the suspect. The first thing we usually do is we author several search warrants, whether that be to social media accounts, emails, phone numbers, or IP addresses, looking for subscriber information along with the account contents. Other ways we can identify suspects is open source or closed source intelligence tools. If we have enough information on the identity of someone, we can use SOS or Lean or TLO, which is a closed source intelligence tool for law enforcement or social media, any open source intelligence.
Do these investigations also involve interviewing child witnesses or victims?
Yes, they do.
Or observing forensic interviews of child witnesses or victims?
Yes, they do.
Do these investigations often also involve the forensic examination of digital evidence or electronic devices?
Yes, they do.
Using some of the same software that you described earlier?
Correct.
In your career, approximately how many cases have you been involved with as an investigator or as an officer in charge?
Approximately around 100 cases.
Have you ever testified about the nature of your investigations in court before?
Yes, I have.
And what courts have you done?
I've testified in the 67th District Court related to these investigations. Also, Oakland County Circuit Court regarding these investigations, as well as the Circuit Court in Washington.
Now, Your Honor, at this point, I would move for the qualification and admission of this witness as an expert in the areas of forensic examination of electronic devices and child exploitation investigation.
No objection for exam.
All right, he's qualified.
Thanks, Joe. Detective Nyberg, now I want to move your attention to July of this year. Were you working that day?
Yes, I was.
And what were your duties that day?
At that time, I was assigned as a detective trooper specialist on the Internet Crimes Against Children Task Force.
At some point during your shift, were you provided a tip or some information about a Google account associated with a person named Aquavion area?
Yes, I was.
And you described earlier that some cases will come to your attention through these tips. Is that correct?
Yes.
So what information did you receive at this time on July 30th, 2025?
We received a tip from Nick Mick from the National Center for Missing and Exploited Children. There's 3 tips in total that were all connected. 2 of the tips were from Google and 1 was from Instagram. Google advised that one of their users had uploaded to their server multiple files of child sexual abuse material, or CSAM. They provided us with the files of interest or the suspected files they thought were CSAM, along with basic subscriber information for the accounts.
Okay, so this tip or these tips come through with subscriber information of like what accounts are involved. Is that correct?
Yes.
Along with the actual potentially offending files. Is that
Yes.
correct? Now, so this is July 30th, 2025, and you received this tip. After receiving the tip, were you able to see the files that were the basis for that tip?
Yes, I was.
And you said there were 11 files in total. Is that correct?
Correct. Approximately 11.
So you actually looked at those files. And before we get into what those were, was the tip also accompanied with specific account information and user profile information?
Yes, Google provided Nick Mick basic subscriber information for that account. They listed the Gmail account in question as aquavionjurgen19@gmail.com and the associated phone number of 248-722-119 for several IP addresses that were used by that account.
Now, after you took a look at this user profile information, did you actually look at the nature of the files that were the subject of the tip?
Yes, I did.
Before we talk about the details of the file, could you explain to the board what metadata is?
Metadata at its basic definition is just data about data. It basically tells the who, what, when, where, why of digital information, such as like when it was made and who made it and stuff, information like that.
Okay, so for example, an image that's captured on a camera or a cell phone would have some metadata, is that correct?
Correct.
That metadata might give you a GPS location of where the photograph was taken?
Correct, depending on the software and the device used, correct.
Okay, so data about dates, like you said. What is EXIF data?
EXIF data, it stands for exchangeable image file format. It's a type of metadata that is only associated with digital like photos and videos.
Sorry. What does EXIF data show?
Depending on the device and other factors, but for example, for a cell phone, the usual information provided will be the device make and model. So the type of phone it was. It will show the date it was made, the last date stuff was accessed or modified. It will show other information about the camera that was used, as well as depending on the software and the device, GPS coordinates of where that device, where that photo or video was taken.
So among the other data, the GPS coordinates for where an image was created, along with date and time.
Correct.
Okay. When you receive these tips, are you able to tell if the offending images have been seen before?
Yes.
And if I were to say the word unfamiliar or unrecognized, what does that mean to you?
It's the terms that Nick Mick will use when they are presented with files. When I say files, I mean like photos or videos that they have not seen before or do not recognize. They keep record using a hash value. It's very similar to a fingerprint for a file. They keep record of all those, and when they see a file they do not recognize, it tends to get flagged because it's indicative to us and a strong indication that it is recently made, or we can consider homemade material.
Now, Detective, I want to talk a little bit more about the actual files provided as part of the tip. During your investigation, did you describe 3 or 4 of these files for investigative purposes?
Yes, I did.
And were these the only 3 files that contained CSAM among the 11?
There were not. No.
Did all 11 contain CSAM?
Yeah, there were approximately 11 files of CSAM.
Why did you only describe 3 of the 11?
It's general practice in our investigations to describe anywhere between 3 and 5 files. We've come across individuals who have thousands. We've had individuals close to 1 million files. So if we were to describe every single one, we would be there until for years.
Okay, so it's an investigative process to narrow your scope.
Yes,
sir. Okay. Now, could you now at this time describe the 3 videos or images that you've also described in your report? And if you need to refresh your memory about file names, you can refer to your report if you need.
Okay, or do you want me to refer to the whole file name, or is it fine just to use the ending digits?
How about, let's first describe for the court the image or file associated with file name and the IMG_3299.mp4.
May I refresh my memory?
I'm sorry.
3299.
Oh, may I refresh my memory?
Yes, if you can't remember the file name off the top, definitely. Just refresh your memory and then we move it on. And for the record, he's got a copy of which on stamp. Do you have any objection?
So the file ending in 3299, it's approximately a 52-second video of a young girl laying on her stomach, wearing a shirt. There's an adult male that can be seen standing behind her. During the course of the video, you can see the adult male's hand touching her buttocks and rubbing it throughout the video, as well as he is slapping his penis against her buttocks. Near the end of the video, you can hear the male state in the video to as he's trying to elevate or lift her buttocks up in the air to arch that back for uncle. Near the end of the video, the adult male places his penis near the anal and vaginal opening of the young girl, and the video ends at that time.
In that video, does the adult male's penis go between the buttocks, so in the cleft of the buttocks of that child?
Yes, it does.
What's the approximate age of the child depicted in that video?
So based off her overall statute compared to the adult male, the lack of pubic hair, I would estimate her age anywhere between 4 to 8 years old. Also very likely that she is younger.
Detective, next, I'd like to describe the image file associated with the file name ending on B668.jpg. B668. And if you need to refresh your memory,
Sure. This is a photograph that we later determined was a still shot from the video, but it depicts the sexual intercourse between an adult male and a young female. The young female is laying on a bed with her underpants pulled down just below her buttocks, with the adult male's penis slightly inserted between her buttocks.
And then third, if you could describe the file associated with the file name ending in 6660_.
This is a video file. We classify it as more of a slideshow or a collage. It contains 3 separate videos edited together to make one video. It begins with a young African-American female wearing spandex walking away from the camera. And in the bottom corner of the screen, you can see an AI-generated image of what appears to be 2 toddler-age African-American females in underwear with their buttocks facing the camera. It appears to us that it was AI-generated. Quickly after that, the video changes to another video. It was the video of the photograph I just previously described. An adult male having sexual intercourse with a young female. She's laying on her stomach with her underwear pulled just below her buttocks with his penis inserted in between her buttocks. The video ends then with another African-American female performing oral sex on a male.
Now, for those last two, for that video and the still frame you described, are you able to determine or estimate an approximate age of the girl involved?
Yes, with the limited information due to the photo, the video and photo being taken from the male's point of view, but approximately based off her overall statute, between 5 and 10, but also likely that she is younger.
Now, for these files, were you able to locate or examine any exif data or IP address data?
There were IP addresses associated with, I would have to recall for exactly which ones, but we did not recover any GPS or exit data for those three.
For the IP addresses, were you able to determine a GPS location for where those IP addresses were?
Yes, so later in our investigation, I authored search warrants for the subscriber information to Comcast for those IP addresses.
Okay. Now, eventually, were you able to pinpoint an address of 273 Delwood in the city of Pontiac?
Yes, that was one of the addresses that the IP addresses came back to.
Now, after observing the files and the metadata for these files, what are the needs to start your investigation?
After we confirmed that what was what we believed would be CSAM, our next step was to identify the account holder or the suspect in this case.
Okay. And based on the phone number and email addresses, were you able to determine suspect name?
Yes, the email address was aquarianjurgen19@gmail. Through my training experience, people often tend to put name or part of a name or part of their birthday in their email address. So using TLO, which is a closed source intelligence tool offered to law enforcement, I searched the name of Aquarian Jurgen, which revealed a possible name of Aquarian DeMarcus Jurgen Woods living in Pontiac. And then took that name and searched it in SOS, that database, which confirmed the same name living at with an SOS address at least of 273 Delwood Ave.
Okay. So you were able to locate an address and a name for that person potentially associated with that Gmail account. Is that correct? Correct. Were you able to look this person up on social media?
We were not able to locate social media for this individual.
Were you able to find any images of that person on social media?
Yes, we located a Facebook profile for who we believed at the time was his mother, DeAndre Jurgen, and located pictures of him on that social media profile.
Now, when you observed DeAndre Jurgen's social media, did you notice anything else found notable about those?
We located several photographs of young African-American prepubescent girls, which resembled the same age and size of the ones we observed in the videos.
It's fair to say that at this point, you conducted the investigation of the DeAndre Jurgen was identified as a suspect.
Yes.
After he was identified as a suspect, what did you do next?
After we, I then authored search warrants for the Gmail account of aquarianjurgen18@gmail.com, and which was submitted to Google, as well as the phone number, which was cannot recall the company, but authored search warrant for that phone number if I can recall.
Okay. If I said T-Mobile, that's not.
Yes, that's correct. And then as well as the Comcast IP addresses were submitted, which they returned 2 different addresses to us.
Now, you've already mentioned the address of 273 Delwood Ave in Pontiac. Were there any other addresses associated with the defendant?
Yes, another IP address returned to 25 Grand Tour Court, Pontiac.
Now, after offering these search warrants for Google, T-Mobile, Comcast, did you execute any additional search warrants?
I authored 2 search warrants, one for the 273 Delwood Avenue, and as well as one for the 25 Grand Tour Court.
Okay. Now, did you execute those search warrants at those addresses?
Yes, we did.
And are you able to confirm that both of those addresses are what they do in the city of Pontiac?
Yes.
When you, did you yourself execute the search warrant at the Delwood address?
I was not present.
Did you attend the execution of the search warrant at the Grand Tour address?
Yes, I did.
And You can tell the court what happened. Regulatory evidence.
The Michigan State Police fugitive team made contact at the door. They knocked. The door was answered, at which point Mr. Jurgen Woods was detained by our fugitive team, and then they cleared the residence and had the residence step up.
Now that is a residence, is that correct?
Correct.
Is this an apartment or a house?
It's more like a townhome, I would assume.
Did you have any interactions with the suspect at that time?
Yes, I did.
And do you see that person in the corner of your head?
Yes, I do.
When you go through and describe something he's wearing?
I used to right there, and he's wearing.
Made a record reflect the identification of that. So noted. Young detective, after the defendant was taken into custody, was he placed under arrest?
At that time, you were detained. Based on our arrest, we were still conducting investigation at the scene.
Now, when he was taken into custody, did you advise him of his rights to not make statements to you?
Prior to our conversation, yes, you were advised.
You advised him he had a right to a lawyer, he had a right to remain silent. Is that correct?
Yes.
You advised him of his Miranda rights.
Correct.
And what was his response?
That he understood his rights and he agreed to answer my questions at the time.
What did he tell you in that time?
Getting the interview, getting some basic information from him. He confirmed his phone number was the 248-722. It's the same phone number associated with the Google account. He also advised that he had a previous email of a cravenjurgen19@gmail.com, but had since been disabled by Google.
Did you tell him why you were talking to him that day?
Yes, we allowed him to look over the search warrant and started a conversation about why we were there.
And did he make any statements about the nature of your investigation?
Initially, he denied any possession of CSAM or sexual assault. Later in the interview, while speaking with myself and resident special agent in charge, Klein, the United States Secret Service, he advised that he had taken pictures of his nieces approximately 4 or 5 times. He described an instance where he took a photograph of his niece, Demaya, where she was wearing polka dot pants or shorts or pants, which was consistent with the videos we observed on Google. Later in the conversation, when confronted about the penetration, initially denied, but later advised that he did insert the tip of his penis in between her buttocks.
And he identified a specific child as being the person who did that to.
Correct.
And what was that child's name?
Demaya.
When you were present at either the grand tour or the Delwood address, did you see any children?
Yes, the initial execution of the search warrant grand tour, no kids were present, but later multiple young African American girls did arrive at the residence.
And based on your training and experience, how old did those young girls appear to be?
Anywhere between the ages of 4 to maybe 10, 12.
How many young girls were at the house at that time?
Approximately 4.
Did you ever speak with Demaya herself?
I did not.
Did you speak to any children?
I did not.
Were they principally interviewed?
Yes, they were.
Do all of the young girls at that house physically resemble the young girls depicted in the videos that you observed?
I would say I wouldn't say all, but the younger ones, yes.
At the time that the defendant was arrested or taken into custody, was anything taken from his person at that point?
Yes, there was one cell phone, which was in his hand upon contact with him, and another one that was recovered from his pocket.
Were those taken into custody?
Yes, they were.
And were search warrants authorized or signed off on to get into those devices?
Correct.
When those devices were taken in to custody by others, would you examine the contents or be someone else?
I had one of our digital forensic analysts extract the information, and then my partner examined the information.
Okay. And the extraction is done with that software you described. Is that correct? Correct. And then the examination can be done with different software.
It depends. Yeah, both softwares have an extraction tool and examination tool. So it just depends on what the examiner uses.
Okay. So to be clear, you were present when these devices were taken from the defendant. You did not conduct the forensic examination of yourself.
I did not.
Your Honor, I have no additional questions.
GROFF.
Thank you. Remember, you indicated, and some of this is for the benefit of the defendant, that in these investigations, the age that you're looking for is under 18 years old.
Correct.
Oh. So you received this tip and you said that initially there were about 11 files
Between all three of the tips, correct?
and you're familiar with the police report that's written in this case?
Yes.
Approximately how many different instances of CSAM were extracted on the devices?
On the actual devices, I do not know. I did not complete the extraction or examination.
Are there more than 3 in reading the report?
On the devices themselves, I cannot say anything about that.
And again, for the benefit of the defendant, because we've had this conversation, because of the sensitive nature of these types of cases with child sexually abusive material, you cannot show those videos to anyone, correct?
I cannot.
Absent specific legal parameters or forward. So you can't send them to the prosecutor because you yourself would be committing the crime of sharing sexually abusive material.
Yes.
Or to me.
Yes.
Now, of course, there are avenues that are available to have that done in a proper way.
Yes.
And then you had indicated that you were at the Delwood address for the search warrant, but you were at the Grand Tour address, right?
Can you say that one more time?
You indicated you were not physically present for the search warrant on the Delwood address, right?
That's correct.
But you were for the other one, Grand.
Yes.
And you had stated that the defendant was there and was detained. Was he cooperative?
Yes, he was.
Was anybody else in that room besides the defendant?
His young.
Just to be clear, when you arrived, I know you testified that later there were more people, but when you first made entry.
Yes, it was his younger brother and grandmother.
You indicated that on one of the videos that there is a video showing a adult male's penis going in between the buttocks of a clearly prepubescent female, correct?
Yes.
Are you able to actually see penetration?
Basically goes between the buttocks. That's as far due to the camera angles that we can see.
And then likewise, you said that you were part of interviewing the defendant, correct?
Correct.
About how long approximately did that interview last?
I don't know if I'd even be able to get an approximate.
Were you accompanied by another officer while you were doing that?
Yes, it was.
And was it video?
Yes.
When you do Miranda rights, do you do them as just a verbal giving of the Miranda rights, or do you use a form?
I read it directly off.
So the form signed, or you just use the form to relay the rights?
Just to say it out loud.
And that's part of the video as well. And in terms of the search warrants, are the officers that involved wearing body cam?
As far as our task force, and their department policy, yes.
And you indicated that when you spoke to the defendant, initially he denied having any possession, correct?
Yes.
And then the conversation continued, and you stated that at one point he had admitted that he had placed his penis between the buttocks of this particular niece of mine, correct?
Correct.
Was there a specific conversation about penetration?
We talked about it. He denied penetrating the anal or the vaginal opening, and advised that the tip of his penis was between her buttocks.
And there wasn't anything to specifically contradict that, correct? Because of the angle of the video or the photo.
I guess I would have to review the files by this time now.
Nothing further.
You regret?
Detective Nyberg, so to be clear, the defendant admitted to placing his penis between the buttocks of a child.
Yes.
And the videos that you observed were of an adult male placing their penis between the buttocks of a child.
Yes.
Okay. No additional questions.
All right, you may step down, sir.
It's time we will call detective. Yeah, if you would have just had it on there, you have them identified. Okay, if he has the device, the exhibit with him, you can spot that and describe what it is before I move.
You swear or affirm subject to the pains of perjury testimony, give this court be the truth, the whole truth, and nothing but the truth. Yes, sir. All right, you may be seated. Thank you. Yeah, we're ready.
Thanks, Chairman. Good morning, sir. Can you please state first and last name and spell for the record?
Justin Norlock, Justin, last name Norlock.
And sir, how are you currently employed?
I am employed with the Northville Township Police Department as a detective and the digital forensic examiner.
Okay. Do you have any association with Michigan State Police?
Yes, I am a task force member with the Michigan State Police Internet Crimes Against Children Task Force out of the Livonia CCU and have been with them for approximately 4 years.
Okay. Now, in that role, what are your duties and responsibilities?
Duties and responsibilities in that specific role would be to handle any investigations. In addition, because I am specialized trained in forensics, that I also would handle any potential digital forensic acquisitions or analysis.
Okay. You're under that.
Yes.
Your Honor, I would move the qualification and admission of this witness as an expert in forensic examination of electronic devices and investigations related to child exploitation.
For exam purposes only, we'll stipulate to that. It would be clear that this officer would have very similar training as to what we've already heard today in regards to being in the task force.
He's qualified.
Thank you, Your Honor. Detective Norlock, are you trained in the extraction and examination of digital evidence?
Yes.
And today, you've already, because you're one of the officers we hired in this case, you listened to some of the testimony, is that correct?
Correct.
And so you heard earlier, Detective Nyberg described the kind of procedure forming an extraction on a device, but can you explain that a little bit further? What is happening when you extract data from an electronic device?
So when you're extracting data from a device, there's essentially 4 ways to extract it. One would be a manual examination, would be simply flipping through a device. The other 2 well-known or more common are either a logical or a full file system. And a logical extraction, which would be using a machine, would be simply just taking basically the framework of the phone and anything the phone wants you to see. In this case, we did a similar thing, which would be a full file system extraction, which is basically taking a bit for bit copy of that phone. So, and then the fourth it would be something called a chip off, which doesn't apply to this, but we did, for this purposes, we did what is a full file system acquisition of the phone.
Okay. Now, if I understand correctly, that basically copies all of the data off of the device and makes a clone of it somewhere else that you can look at.
Yes.
And that means that the device itself is not being manipulated or changed at all. Is that correct?
Correct.
And so you can then look through the contents without risk of corrupting or manipulating or changing any of the stuff over the device itself.
That's correct.
Okay, so that's what happened in this case.
That's correct.
In this case, what was your role?
In this case, it was to assist Detective Sergeant Nyberg at the time of the investigation. And then additionally, after the acquisition was the examination, parsing of the data that came over and examining the contents of the phone.
Okay. So in this case, you received certain devices associated with the defendant. Is that correct?
That's correct.
And you performed forensic examination of the data. Is that correct?
That is correct.
Did you perform the extraction?
I did not perform the extraction.
Who performed the extraction?
A digital forensic examiner within the Michigan State Police, Brian Bull, completed the extraction.
So like you said earlier, or you confirmed earlier, the extraction is not creating anything. It's basically copying a device.
Correct. It's creating a working copy in which we could all read and it will be the same duplication of a copy that anybody can have.
So Detective Vogel does the extraction and creates this copy. And then you look at the copy for your examination.
That is correct.
Okay. Can you describe in general what you found during your examination?
Yes. So through the examination, there was two devices. There was an iPhone 6 and I believe an iPhone 11, both described by Detective Sergeant Nyberg of recovering from the suspect. Within that device, we found approximately 43 videos of CSAM, over 200 to 300 images of CSAM, including some videos in which some XF data that we spoke about that contained GPS coordinates of those videos.
Okay. So that was going to be my next question. Whether EXIF data was recoverable or viewable for any of those files. Were you able to find GPS or date and time EXIF data?
Yes, I believe on most of the videos, we were able to find dates or times, modified access created. I believe on 14 videos, we were able to find dates, times in which we were able to place it at Delwood. 9 of the videos contained GPS coordinates of Delwood.
Okay. Now, what does that EXIF data tell you? I guess maybe I'll re-ask this. The GPS information in the EXIF data, is that indicative of the location at which the image or file was created?
That is correct, yes.
Okay. You've already described the general nature of the images and videos that you found on that device. Have you brought those images with you to work today?
Yes.
Now, when you hold up, you've got your laptop up there, and it looks like you've got some other devices plugged into there.
Yes, it has 2 external drives. The first drive with the label 256 GB. Excuse me, I apologize. Sorry. That would be the silver one. This contains attachments in which reports in which we're able to just read them and actually view this. The second blue one is where we create a portable case. And essentially what the portable case allows us to do is take that phone and the data anywhere, open it up as if I was able to view it while the data is being parsed and searchable.
Okay. Which of those external drives contains the evidence that you just described?
Both, but the one for the purposes of this would be the 256 GB, 256 gigabyte drive. Contains that.
Your Honor, I would ask that that silver flash drive be identified as Exhibit 1. Now, on that, Detective, we've designated 5 files as People's Exhibits 1A, 1B, 1C, 1B. Before we get into this, I first just want to ask, again, have these files or videos been altered in any way from how they were on the defendant's device?
No.
Are they fair and accurate or true and correct copies of the data or information taken from the defendant's device?
Yes.
People who from the initial People's Exhibit 1A, B, C, D, and E.
Can you objection?
Not for exam purposes, Your Honor.
All right, minute.
Now, before we publish these to the court, Detective, could you briefly describe what each of these files, I'm just gonna ask by their exhibit letter provider.
May I reference the report for Nemus?
You may. First, People's Exhibit 1A, this is file ending 2243. .mt4.
Yes, that is the 52-second video in which Detective Sergeant Nyberg had described earlier in his testimony, in which a young female in a pink shirt, in which a male is then talking with his erect penis and appears to insert his penis into her anus.
Is there audio in that video?
There is audio, yes.
Prior to testifying today, did you have an opportunity to meet with a witness named Courtney?
Yes.
Courtney Yergin?
Yes.
And did you play for her the audio portion of that video?
A very short snippet, yes.
Okay. Now moving on to People's Exhibit 1B. That is file ending in IMG _0440 .mo.
Yes, this image or this video is approximately 1 minute and 23 seconds. It is what appears to be a different day, different clothing of a child in which a male is rubbing his erect penis with a substance that appears to be coming out, which could be inferred as semen, in which he is rubbing on the buttocks of what appears to be a 2 to 3 year old child. And then during the video, it appears that the penis begins to enter the buttocks, anus of the child.
Okay. Now, this exhibit was a still frame this video shown to Courtney's mom.
I believe so, yes.
Now moving on to People's Exhibit 1C. This is the file name ending in 9138.mov.
I'm sorry, just sorry.
9138.mov.
Yes, this video is approximately 1 minute and 30 seconds, 36 seconds long. It shows a female approximately 2 to 3, approximately the same age as in the previous videos describing which a male is using his hands and rubbing the buttocks. At one point, it appears that the male enters a knuckle into his.
Okay, guys, it's up to you. This is obviously a very graphic situation. We can continue with it, or we can move on to something else. I'm torn because it is very graphic, but in the same respect, this is such a pervasive issue in our society right now. It is everywhere. There's also the argument to be made for preserving this and shedding a light on it. 1 in the chat if you want to stay, 2 in the chat if you want to move on to something else. Let me know.
Not the same video in which it depicts a child with only what appears to be a 2 to 3 year old laying with the buttocks exposed, with the male's penis rubbing against the child's buttocks with a glistening substance, which is common semen, in which you can see semen being wiped from the penis onto the child's buttocks.
And then finally, People's Exhibit 1E, which is the file ending 9090.mov.
This video is approximately 1 minute and 15 seconds. Again, it shows a similar stature of child on a different time and date. The child has an exposed buttocks, and the suspect is squeezing the buttocks to make it kind of jiggle, in which he's caressing and then stroking the buttocks and the anus with one of his fingers.
Yes. Detective, Was there GPS location data available on any of those videos?
3 of the 5 videos, there was GPS data associated with those images.
And are those 3 People's Exhibit 1C, 1D, and 1E?
That is correct.
What GPS coordinates or what address were associated with the creation of that?
All of those GPS coordinates were plugged in and they come back to 273 Delwood.
Not a bad response. No additional questions for this witness at this time.
Okay.
I'll move to public reports.
Cross. I guess my game plan is to publish. Now you have to step out in the hallway. We publish these videos and my deputy will let you know when they're making understood.
Not as far.
Because this is CSAM and we are authorized court employees and this is a legal proceeding. And of course, I have to see it as a judge, she does, and these officers, but you're still a member of the public. That's why.
So it would be a crime for us to allow you to see it. As the defendant, he would be allowed to see it, but it would be a crime for him to allow anyone not directly involved in proceeding to see the video.
No disrespect to you, it's just the law, okay? So he'll bring me back in when we're done watching it. All right, you may proceed, because my.
Thank you. Is your title Detective Sergeant?
Detective's fine.
Okay.
Thank you for the promotion.
Involved in the interview with the defendant?
I was not.
In going over these videos, these 5 videos that have been admitted today, you had just what's first A, or what was described as video 1A. You indicated that it was a young female in a pink shirt. You had used the words that the penis goes between the buttocks and appears
Correct.
penetration. So obviously, when you say appears, are you able to see penetration into the anus?
By a legal definition, yes. It does begin to insert, but it's different. It doesn't fully insert, frankly, because of the size of ears.
Okay.
So just the tip.
Okay.
Yeah.
But you are allowed to visually see that in the videos. I know we're going to watch them shortly.
Yes, ish.
Okay. And when you say a legal definition, clearly we are all familiar with the legal definition. You indicated that there's some audio and that there was audio in that particular 1A.
That is correct.
Okay. Are you able to see the face of the child in that video?
You are not able to see a full face at one of the points in the video. If you stop it correctly, you can see approximately the right ear and probably the cheek, the right cheek, briefly.
And are you able to see the face of the male?
No.
Again, the video B, you again described the penis appearing to enter the anus or the buttocks.
Correct.
Using the legal definition, are you able to visually see that in the video?
Yes.
You described video C as a female approximately 2 to 3 years of age with an adult male rubbing hands on buttocks, and then described that it appeared that a knuckle on his hand entered the anus.
Correct.
Again, are you able to see that in the video?
Yes.
How do you determine, we've heard testimony about how you determine at least the approximate age of children, whether they're male or female that are depicted in the videos. How are you determining that the male depicted is an adult?
By the hand size In a few of the videos, you can hear breathing, heavy sighing, and specifically I believe 1A, you can hear a deep voice. His penis is of male stature. So you can see physical depictions, which he is post-puberty, and he's gone through if not all stages of puberty at that point.
Okay, friends, so here's what we're going to do. The vote seems to be to stick with this. And again, I feel a little bit conflicted based upon the graphic nature of this, but also I think there's a case to be made for preserving this, because these kind of videos from these courts don't tend to stick. They tend to get deleted, but the more information that is out there about just how bad the situation is, the probably better off we are to someday get it at least under control, because right now it's really out of control. So I'm going to continue to run with this, but I'm not going into overtime. And to help make Ashley happy, at about 10 minutes to go, we'll dip into dungeon court for a couple of minutes and spend some time there. So I think that's the best way to do it. So we're not going to do this for overtime, because this thing's going to go on for a while, but preserving part of it I do think is helpful for the public. So I think that's the play, if everybody's happy with that. Plus, I'm going to bump it forward a little bit here, because they're about to show all this stuff to the judge, and we don't need to sit here while they do that. And we are in the Wayback Machine by about 30 minutes, so let's bump this forward.
This time, people call Courtroom.
There we go.
Follow me up this way. Just have a seat right up here.
Please start and raise your right hand. Do you swear or affirm subject to the defendant's bills of perjury testimony you give in this court will be the truth, the whole truth, and nothing but the truth?
Yeah.
You may begin.
Thank you. Good morning.
Morning.
Good afternoon. How are you this morning, or how are you this afternoon?
I'm all right.
Please state your first and last names and spell them for the record.
Courtney Jurgen Jones. COURTNEY Dash Jones JON.
Thank you. Do you mind if I call you Courtney?
Yes.
Courtney, how old are you today?
29.
And what city do you currently live in?
Pontiac.
And do you know a person named Quadion your influence?
Yeah.
And who is that person to you?
My cousin.
Do you see that person in the courtroom here today?
Yeah.
Can you point to them and describe something he's wearing?
It's orange.
May the record reflect the identification of the defendant.
So noted.
Courtney, do you know the defendant who ever lived at 273 Tillwood Avenue in Pontiac?
Yeah.
And you also know of the defendant living at a 25 Grand Tour Court in Pontiac?
Yes.
When the defendant.
Yes.
Right, so like we talked about earlier, everything we say is recorded with your voice up, so everybody. Thank you. When the defendant was living at Delwood address, who else lived there with?
DeAndre Jurgen, Cameron Allen, and Dallas.
In Dallas.
Dallas.
And who's Dallas?
My little cousin.
And is Dallas a boy or a girl?
A boy.
And how old is Dallas?
He's 3 now.
when the defendant was living in the Bellwood address, were there any young girls who would spend time at that address?
Yes, my other little cousins.
And
His
what-
siblings.
And what are their names?
Demaya, De'Ara, and Dakota.
How old are Demaya, Kiera, and Dakota today?
I think Demaya is 8 or 7. De'Ara, maybe 6 or 7. And I think Dakota might be 5 or 6, somewhere. They all stair step, so I'm not quite sure.
Okay, they're all under the age of 10.
Yeah.
Courtney, I want to direct your attention to August 6th of this year. On that date, were you tasked with taking the little girls to care house?
Yes.
And that's over on Courtroom, is that correct?
Yes.
And who asked you to take the girls over to care house?
I was contacted by a worker from there to bring them down to evaluate all the girls, including my daughter as well, Denise.
Did you know those girls to spend time at that Bellwood address frequently?
Her grandchildren.
Who's grandchildren?
You talking about De'Ara, Dakota, and Demaya?
Yeah.
Yeah, quite often.
And so
Here and there.
Deandra is their grandmother, is that correct?
Exactly.
Deandra is the defendant's mother.
Yes.
Do you know if the girls would ever spend the night at their grandmother's house?
Yes.
So all three of the girls are under the age of 10 and you've known them to spend the night at that address
Yes.
while the defendant was living there.
Yes.
Now, Courtney, before you took the stand just now,
Mm.
you and I had a chance to meet with the detectives here at the courthouse, is that correct?
Yes.
And at that time, were you shown a still image?
Yes.
And can you describe to the board what you saw in the still image?
Dark complexion, earrings, ears. And it looked like one of my little cousins, either De'Ara or Dakota.
And why do you think that it's either De'Ara or Dakota in that image?
Because I know their body and their face. I've been around them all my life.
Now, when all three of those little girls were toddlers, did they all look fairly similar?
They look a lot alike.
They still look a lot alike.
Yes.
Have they all had their ears pierced with what one?
Yes.
In that image, you don't know specifically which one it is, but it's your belief that it's one of them.
Yes.
Okay, friends. So, update on this situation. Again, we're a little bit in the way back machine on this, probably about 15 to 20 minutes worth now. But it has concluded live now. I think we've preserved enough of this to make a point to the public. So I'm going to go ahead and go to Dungeon Court in a second. I know this was rough, but I've got a little bit of a passion about trying to, and I didn't go here on purpose. We just walked into this. I had no idea what this hearing was going to be. It was just a new court for us that I wanted to check out, and this is what we got. But I think we've preserved enough to, again, continue to show just what a pervasive issue this stuff is right now in our society. And at some point, we've got to wake up and actually start doing something real about this, because it doesn't seem like any progress is being made. If anything, we're losing ground, because we've seemed to have just decided that we have no morals or ethics anymore, and that really disturbs me. And you guys, I think, understand me enough to know why that would be so disturbing to me. Anywho, the update here, they have concluded the hearing live. Judge expressed his disgust, bound him over for trial in the circuit court, and he is being held no bond. So that is not an unexpected outcome, but very nice to see that he is being held no bond. So that is good, because, you know, it seems like so often with these kind of charges, when it's all said and done with, the judge takes him out to dinner. So I'm glad this guy actually did the right thing and didn't give him a bond, which makes me want to come back to Judge Jeremy Darnell Bowie sometime in the future, and maybe we can do something a little later with him. But it is a Friday, and it's weird to go from one sort of evil to another sort of evil just to cleanse our palates. But let's do Dungeon Court, and you can't make this stuff up. Just look at what it says on the back of a hoodie of one of the Dungeon Court contestants, and you'll get a chuckle.
Do you have a job now?
Yes, sir. I work at Applebee's.
So your schedule is flexible, or do you have, is Monday or Friday better for you?
It doesn't matter. Either one would work.
Okay. I'm going to set you for this. Yours is a newer case, so I'll give you more time before your next hearing. December 29th will be your next review hearing at 9 o'clock. Go see the clerk and make a payment. Talk to Mr. Cooper before we go in.
Yes, sir. Thank you.
You're welcome. Andrew Carr, 24/7. He's on teleconference and he's at the counseling center. Yes, Mr. Carvin is here and has a report. How are you, Andrew? I can, yes. I'm reading the report that Mr. Tarver said. Okay, it's a good report. Doing what you're supposed to with the counseling center. Tell me what's going on with you. Do you have a job yet, or what's going on? I'm in the hospital community. I'm still into they're trying to follow. They're trying to get into one of the things. They're trying to attend. Okay. I'm doing that. I'm done eating. I'm done with church on Sunday. Sometimes getting connected with a local church here. That's been a weird part. Something that over at Dallas Farm. Okay, I know there's a waiting list for that.
Yeah, I called for clarification this morning on the way here, Your Honor, just to see what that looked like, and they're a ways down on the list right now.
Okay. All right, well, I want to see you back on before Christmas, so let's make it the 22nd, December 22nd. See you then at 9 o'clock. Okay, keep doing what you're doing.
Thank you.
Jessica Christian. Jessica Christian is 183566, 19255, 222505. Jessica Christian is here. And all you're working on are fines and costs and restitution. You have a payment today. How much are you going to pay?
20. I'm also paying through the insurance company too.
I'm sorry?
I'm paying through the insurance company
Okay.
too on it.
All right, well, you'll see the clerk to make your payment. And I'll set you for December 22nd also as your next hearing, 9 o'clock. That's a Monday.
22nd.
Yes, ma'am. December 22nd.
Thank you, Your Honor.
You're welcome.
Have a good day.
Missy Dotson, 23706. So I'm going to be just working on your fines and your counseling at Marshall Health.
I'll be paying 10 today, Your Honor.
Okay. Okay, you got a good report from Marshall Health.
Thank you.
See the clerk to make your payment. December 22nd, is your next hearing, 9 o'clock.
Thank you, Your Honor. You have a good day.
You too. Corey Easton is here. Corey has a report with her. It's case number 24-247.
24222. Says you're consistently engaging, so that's good. That's what you need to do.
I also graduated the program.
Okay, great. You paid all your fines and costs off. So I'm going to suggest, it sounds like it's really helping you to continue with that, but I'm not going to supervise it anymore. So I'm going to close your files because you paid all your fines and costs and you guys are completed.
Okay,
Congratulations.
thank you. Thank you.
Connor Harrison. Okay. The only thing I think you need to do is the driver intervention program.
I go January 22nd.
You're signed up for it then?
Yep.
Okay. Well, we'll go past that for your next hearing. If you get proof of it filed with the court, you don't have to come back.
Okay, do I just like drop it off at the clerk's office or something when I get it?
Yeah, just make sure, usually if you're going to the one locally, they.
Yeah, I'm going to the one in Ironton through Large
they'll
County
file
Recovery.
with us.
Okay.
I would just check in to make sure it did get filed.
Yeah, I will.
And what's the date you're going in?
January 22nd.
Okay. I'm gonna set it for January 30th then.
Okay.
So that gives, a week to get it in filed.
Gotcha.
And if it does get filed, that's all you got left. You don't have to appear.
Thank you.
You're welcome. You're free to go. Susan McCann, 21-134, 21-23.
On my community service, I talked to Miss Piles about paperwork, and she sent them to Carl Bowden.
Oh, okay, that's.
So he was supposed to send them over here. I've got pictures of where I signed in, though.
I have not received them yet,
Okay. And was that, you did it at Ironton Municipal or?
No, Miss Pyle, Lou
Oh,
Piles, the Hana Tunnel.
Oh, okay. And that's something you approved, okay. Well, we just need to get it here to the court. You completed it at Lawrence County Recovery. So you just need to pay off your fines and costs. Are you making a payment on those today?
I made a payment this morning, online.
Oh, okay, so that, it takes at least a day for those to show up. Okay, I'll make yours December 22nd also for your next reading. 9 o'clock, December 22nd.
Earl Holton, Adam Raymer, Michael Rowe, Alexis Smith, Carl Tula II, Donald Wilson Jr., and Gordon Wolf.
Earl Paulton, 24, 25, 28. Community service done. A lot of community service done last time frame. Are you paying anything today or are you gonna work it off?
I'm gonna continue to work it with him because
That's fine.
if you don't mind. Every time I try to do that hotel, 3-door hotel, they keep telling me to book up. The one in Ironton, and I don't know how to find any other ones.
Oh, disc school?
Yeah.
Well, you have to do it.
Yeah, I'm trying. Every time I call, they keep saying it's booked up.
They should tell you, they usually know when the next date is, like they're doing one in January. I don't know if there's any openings then.
I could call, but when I called, they said that lady wasn't going to be back until the beginning of the year.
that is January 22nd. We just had someone today say they're signed up for the.
I know I did, that's what I heard. When I leave here, I'm gonna try to call again.
Okay. Because the law in Ohio is, if you don't go to that, I have to make you go to jail, so. You don't
Right.
have to go to jail, I'm assuming.
No, I don't really wanna go to jail, sir. I lose everything then.
Okay, so let's get you another date. December 29th.
The 29th?
29th of December, that's a Monday, 9 o'clock, will be your next week. Adam Reimer, 22
Have a blessed day.
through 27. You too. Adam Reimer has been counsel.
Your Honor, Adam was admitted into the hospital last night for an infection in his arm.
Okay. Well, let's just continue. You can let him know, then I'll continue to. Is he inpatient then, or?
Yes.
Okay. Let's go out at least a couple of weeks. Let's see what we got. Let's do December the 12th. I'll make his next hearing December the 12th at 9 o'clock.
Thank you, Your Honor.
And he's compliant otherwise?
Yeah, he's doing well.
Good. All right, thank you.
Thank you.
That was Brian Tarvin from the Counseling Center. Okay, Michael Rowe, 23-4. Michael Rowe?
Yes, sir.
All right, he's appearing by teleconference. Okay. Have you done anything since your last hearing?
No, Derek told me I could complete these classes, and my probation officer down in Gallaudet told me it's a minimum of a 90-day program, and 90 days puts me around December 23rd of next month after I complete my classes. They said there might be a possibility for me to leave early, but I'm not going to hold my breath on it, so around December 23rd, whenever I'll be leaving this halfway house and heading back to my address, to my parents' house.
What's your location now? Where are you?
It's 5232 West, West State Route 63, Lebanon, Ohio 45036.
Okay. I'll set your next hearing then in January, after you get released from there.
This Wi-Fi buffer, I didn't hear the date. You said January what?
I didn't. I just said January. I didn't give a date. I'm going to make it January 12th.
January 12th? All right, and then you want me in person?
Yes.
You want me in person for that one?
Yes, unless you're in another facility. If you're in a treatment facility or something, you can appear by teleconference.
All right, I appreciate it.
All right, you're welcome. Alexis Smith, 193668. Alexis Smith. She had been at the counseling center. Ryan. The last report I have was October 7th. Alexis Smith, do you have anything on her?
Actually, that's what I was out there doing right now, Your Honor. So I had received a report for her that was put me under the impression things were going well, but I just reached out due to the fact that I didn't see her in here, and they said she's been a no-show for her last couple visits. So I'm trying to get clarification of what the situation is right now.
Okay. Well, at this point, I'm going to say she didn't appear and appears that she's not compliant with treatment. At this point, I'm going to go ahead and order a warrant issued for failure to appear. If for some reason you think that shouldn't happen, and find out something additional, just let the staff or me know about it.
Yes, Your Honor.
Thank you. Carl Tooley Jr. I'm sorry, Carl Tooley II, actually. 05-1584, 05-1474. He's at Hometown. Looks like there's been a problem with your screen. So there's some question whether it was legitimate or some sort of cross-contamination. Okay, I think what we need to do today, then, since there's some question whether this is a legitimate test or not, I want you to do a urine screen here.
Okay, yeah, I
So
took
do
one this morning.
probation, do a urine screen, and then come back and we'll decide how we're gonna go forward.
Okay.
Thank you.
So he'll be recalled later.
All right, friends, we've reached that time. Thank you for joining me today. I know it was kind of a weird day, but a good day nonetheless, I think, because I have deemed it thusly. I like good days, so we're just going to have them all be good. As my phone rings from somebody I do not know. Aura, step in, take care of that for me. 14-day free trial, by the way, link in the description for that. So be sure to check out Aura. Okay. Let's get on with our day. Go have yourselves a good day. Have yourselves a good weekend. It was nice to be back this week. I missed you guys the 2 weeks we were gone. So happy to be back in the chair. So happy that we'll do it again Monday, 10 a.m. Eastern, 7 a.m. Pacific. 45 minutes early for channel members. If you're not a channel member, take a look at fixing that problem. It's $2.99 a month. You get a whole bunch of things, including access to the pre-show, and we'd love to see you there. So, like I said, go have yourselves a good day, a good weekend. Look forward to seeing you all Monday. Take care. God bless.